same 44, my lord, will kindly see. The next matter, my lord. 44 to dia. There is the same matter, my lord. Connected matter, my lord. 44 to dia. 21-7 order, my lord. 44 to dia.
44.
It does not do that. Bail application. 44. My lord will kindly see. This is the connected matter. 44 to 7. Quashing, my lord, with regard to the same petition, my lord will kindly see the order sheets. 21-7 order. This is bail, my lord, item number 1, and 44 is the quashing of Sandipan Garg, same person. And this is the order. 21-7 explicit order. So whatever prosecution relies in, my lord, these are furnished document to me as
No,
a
I mean, there is no order here.
21-7, there is a order.
1 second.
Criminal petition, my lord. There is order, and we have checked it online also. 21-7. Positively, scan copy of this.
Yes, whether those are received.
My lord.
Scan copies.
My lord, scan copy is get through the registry, not through us, because these are court documents, my lord.
Yes.
They are
it's-
only in hold of the case diary, my lord. These are case record, my lord. We cannot do anything, my
So,
lord.
I mean,
Registry-
whether it has been received. I mean, I don't see any. I can't see any.
Nothing, I also don't see it, my lord.
So let me make my submissions, my lord.
Because in
Let us
the,
proceed
there
with
is
this case.
no note given,
My lord, whatever the prosecution will be relying in, my lord, all copies we have made in extra so that we can save the valuable time of the court, my lord. Here in this case, my lord, I have been after cooperating with the investigation.
No, without the record, how can we go through it? How can we hear?
First,
this?
the notice will go,
Ma-
records will be called for, then hearing will take place.
First they normally, usually, my lord.
No, my
notice will
dear
go.
notice.
This
we
is a
will
motion
receive
stays,
this.
Mr.
Then let the quashing petition be taken up.
It's a motion stays. I mean, we'll have to issue. I mean,
My lord, what I am on, my lord, at least, my lord, my submissions may be recorded, my lord. One step further we go.
no. I mean, motions. There are so many matters. Why should I give preference to this matter?
Why? Because
Why
of the-
should I give preference to this
My
matter,
lord,
Mr.
may I
Bhuya?
submit, my lord, with all
Yes,
respect?
yes.
It's not a question of giving, my lord, preferences.
Yes.
It is a matter of a valuable right of a person.
I understand that.
My lord,
So
may
it
I
has come
submit,
in
my
the,
lord,
no, it has
with
come
all
on the
respect
motion
to this-
stays. It
No,
has
my lord.
come on the motion stays. We'll call for the records and we'll hear it in the due process whenever. We are not saying that we are not going to hear it. But it is a motion stays. In motion stays, we do not hear the matter at length. You can submit.
My lord, what I am on is this. Let it be this way. If it is possible, my lord, it's just a prayer from a person nearly 2 months. After moving the quashing petition, my lord, after quashing this bail application, it's been behind the bar. For this reason or the other, it's available on record. Now, if judicial orders are being passed by this honorable court, and this is not first time on 21-7, scan copy has been called for, and no response has been there from the registry, my lord. And in that case, my lord, whatever documents the prosecution has submitted during supply of copies, we have made extra copies. It cannot be beyond that, my lord. Whatever they will be making submission from this record only. Every record with regard to this is been part of this record, my lord, voluminous. Some records which has nothing to do with this case is been furnished to us. So far this accused is concerned. I have brought this copy, made copies of this, so that I can assist this honorable court to come to a conclusion, my lord. What is required? The case diary, every material has been, I have a copy of it, I'll place it. Whatever they, my lord, read from the case diary, I'll make it available to the court. It has been furnished to us. It's not a case wherein a person is under investigation. It is a search matter, my lord. All document which is prosecution is relying has been supplied to us. And this is, we made extra copies so that we can proceed with the case, my lord. That's my respectful submission, my lord. 2 months it's been there from this court to that court, my lord. I pray very reasonable, my lord. Let my part be over, my lord. If your lordship wants to fix it, otherwise, my lord, what will happen? My lord will hear it, another date will come in. If it is not been part heard, another again starting from zero.
No, that's the different thing, but thing is that there is a process we follow here. So
Here is a such case, my lord.
Chassis case, that's why that is why it's more important. I mean,
Yes.
to get all those I mean,
Documents, my lord, whatever prosecution has given, I place it before the court. 2 bags, my lord, I bought it to assist this court. That there is absolutely no case, even then per person is behind the bar, my lord. That's the irony part.
that's a different thing. I mean, now what is the stage of the this thing?
80 witnesses, 89 witnesses, huh? 89 or 88 witnesses.
How many days have passed now?
44 days working hour, 44 working days, we have examined 89 days.
89. How many witnesses are there?
There are 349, but we have trimmed down, we have burned it. So very few will be examined, my lord. The main witnesses are, of course, from the eyewitnesses account, my lord.
So
But-
trial is going on in a
My lord,
reasonably good speed.
my lord will kindly
See,
allow me, my
it is
lord.
going on a very
My lord, that is not the case. Where there is no case, even then charged as a frame, my lord. That's why caution is there. Absolutely no case, my lord. My lord will be surprise shock to the conscience, my lord. Let me place the materials, my lord. I pray with folded hands.
That this one, I mean,
Let the quashing be placed, my lord.
quashing, we'll see what is there in the quashing. I
Yes.
mean, but as far as this one is concerned, I mean, we cannot hear the whole matter today.
Let me move it at least.
I mean, you can, I mean, we will
Issue notice and call for.
we'll issue notice and like we'll call for that thing.
At least let me move it, my lord. At least prima facie, my lord. Place the facts.
Yep, no, you place the facts. I mean,
Yes,
we
yes.
can hear you.
My lord, sir, handing over the belongings of the deceased and the body of the deceased to the wife of the deceased. He was called in connection with this case several times.
Hmm.
He went cooperative. Ultimately, he was arrested on 8/10/2025. Today is 309 days.
Hmm.
Now, my lord, copies were supplied to us by the prosecution on the point of charge, my lord.
No,
I-
you tell me from the very beginning.
Yes.
Very beginning, I mean, how was his conduct after his death?
After his?
After his death, the victim's death,
Yes.
what was his conduct?
Yes, my lord. I'll come to that. His conduct is this.
You tell me from the very beginning.
Prior to his death, my lord,
Hmm.
I'm start from prior to death.
Hmm.
When he was, a proposal come from one of the co-accused, Mr. Shekhar,
Hmm.
that let us swim to the other side of the shore. Then the deceased expressed his desire. Moyuzam, that were the words.
Hmm.
Then this is the accused person who stated,
Hmm.
no, absolutely no, no, nazaba.
Hmm.
Even then the deceased went and get drowned.
Hmm.
Does it make out a case of 304?
That we'll examine. Yes, done.
And my lord, will kindly go to the record one. It will speak in volume, my lord, what is there. Now, may I take your lordship to the my
Then what
petition?
happened? What happened? Then he went there, the victim drowned. Then what happened? Then
Down.
after
and
his drowning,
thereafter-
after his drowning, what was his conduct?
Yes, he was at a far distance, my lord. He went. He pulled the deceased with regard to the yacht.
He pulled the deceased.
Bring the deceased, my lord. Helping the.
No, you say tell properly whether he pulled the disease. He went to the sea
Yes,
himself.
he went to the sea along with others. The person concerned who was drowned was brought to the yacht. He gave CPR.
He jumped into the sea.
Yes, he gave CPR all along.
You said he jumped into the sea.
Yes.
And then
He jumped into the sea, tried to save his life, giving CPR mouth to mouth, and brought the person concerned to the hospital. He was all along there. When it was declared dead, he brought the body to Gauhati also. Hand over his all materials to the wife also. That is his conduct.
He called up his wife.
My lord?
He called up his wife immediately.
My
Because
lord?
he's supposed to be a cousin brother.
Yes.
He called up his wife.
My lord, at that distress
No,
of mind.
is there any, see, we just want to understand.
Yes.
Okay. Understand the conduct and human behavior.
Yes,
So he's supposed to be a cousin brother.
yes,
Yeah. So cousin brother, what he will do immediately?
yes,
He will immediately inform his family, the deceased family,
yes.
whether he did it.
My lord, from the record, it doesn't appear. It appears that he called up, my lord, the
Call up
cousin sister of the deceased and informed what has happened.
Cousin sister of the deceased,
Yes,
but not
he's
the
a
wife. But
prosecution
not the
witness.
wife.
Not about he didn't have the guts to call it. He was in panic. He is in love. He tried to save the person. A person dies. A person behaves in different manner in different situations, my lord. Making a call doesn't make a call doesn't make a case of
He's
court
a
treason of
senior.
court.
He's a senior police officer, Mr. This thing, Mr. When this is he's a senior police officer.
My lord.
And what kind of responsibility he's, I mean, like what kind of responsibility he is, I mean, carrying out with this kind of things.
What kind of responsibility, my lord?
Means,
for it happens, my lord?
I mean, a senior police officer.
Yes,
He's a cousin brother of the
Yes.
deceased, and he didn't call up his wife.
my lord. Deceased wife, my lord. He didn't call up deceased wife. He called up deceased wife, deceased sister, and his own sister, Pami Bothakur. My lord, calling or not,
Bhai Bhatak is whose sister?
my lord, one of the sister of the deceased.
Okay.
And my lord, calling or not calling, my lord, conduct
No,
is a different issue.
see, that's a different thing. We are trying to understand his conduct. That's all.
My lord, kindly see what is his conduct. It is there on my papers. My lord will kindly come to paragraph 6,
Paragraph 6 of.
my petition.
No, we'll not go into details. I'm just hearing you. I mean, like on the factual part.
Yes.
Then we'll have to issue a notice on this.
And my lord, this will be the argument in the quashing case also, my lord.
No, then we'll have to wait for some time. We'll have to issue a this thing on this.
Already there is notice, my lord, and direction is there to produce the records.
So the records are not here.
And this record, I am making it available.
He file an affidavit and file all these things before the court.
My lord, it's a voluminous.
He
this
file an
one.
affidavit. He file an affidavit, brought all these things before the court. Without that, the record is not there. How can this court can rely on your documents?
My lord, whatever they
without
rely
the
on, these are prosecution documents, my lord.
Correct.
Whatever they rely on, I will place it before the court.
So you
Court is
file
being
an
filed
affidavit
through an
to that extent.
And even I rely on this document I have submitted on affidavit. And there is no case.
Yes.
My lord, paragraph 6, my lord will kindly see.
Hmm.
Paragraph 6, these are the persons, 10 persons who were in the yacht.
Yes.
Their 161 statement I have annexed. They are prosecution witnesses.
Hmm.
These 10 persons, my lord, no one whispered with regard to any instigation on my part, the instigating the deceased.
These are also accused, right?
No, these are prosecution witness.
These are prosecution witnesses.
Yes.
They are, no one of them are accused.
Whispered with regard to any foul play by me. To the contrary, they have stated in their 161 statement that I prevented the deceased from going to water. But even then he went. And that when he was drowned, my lord, he was brought to the yacht, that this accused person tried to save him. CPR was given, mouth to mouth was given, my lord. Now, my lord will kindly come to, my lord, the order of charge, FIR, my lord, first, at page 26. Is the FIR, my lord, 19/9/25, wherein, my lord, multiple FIRs were there all over Assam, my lord.
Yes.
And on the very basis of this, my lord, case was registered, my lord, investigation proceeded. Am I clear? This is a person who has never been in, my lord, Singapore. It is lodged in Gauhati, my lord. Now, 35, my lord, will kindly come to 35. It starts from, my lord, 35. And this charge sheet has been submitted on, my lord will kindly see. The date is 12/12/2025. Can you note that, my lord? 12/12/25 charge sheet has been submitted, my lord.
Yes.
Now, so far, with regard to my allegation in the charge sheet is concerned, 330. It won't take much time, my lord. 330. It's a voluminous one. 330, my lord, will kindly appreciate that, my lord. Yes.
It will
This-
take some time, Mr. Kumar.
Definitely,
Then
fine.
we'll take it up.
Because I have to respond and I will show my
no.
from the
Let me
methods.
finish off all other things.
No issues, my lord. At two, my lord.
Let us finish off some of the matters.
My lord. I'll
Then
leave it to your
about
lordship.
around 2:30 we'll take it up.
230.
2:30 we'll fix it up.
No issue.
Then 2:30 we'll see what is.
Well, we have
Fine.
another two more items regarding 30. All this may kindly be tagged in, my lord. This is 44.
The
44,
one is 44, that is a
Yeah,
criminal revision.
1,
Yeah.
2 plus
Oh, yes.
44
Quashing petition.
plus
1, 2, and 44.
30 and 33, I believe.
30.
30 and 33
so
by
that-
whom?
33.
My lord.
30 and 33 filed by whom?
30
one
is filed
second.
by Siddharth Sharma, the main accused, and Shyam Kanu Mohanto, 33, my lord.
But 33 somebody else is appearing probably.
Wait.
I'm
I'm appearing
He is
for
on 1 to 44.
1, 2, and 44.
1, 2,
And 44.
1, 2 and 44. Others will see, other ones will see what is there. But this matter will take it out, we'll see at 2:30.
230.
My lord, because all these are
But the-
arising out of the same case diary and same case, my lord.
Ah.
So it will be comfortable at one go.
Okay,
All the five
2:30
matters?
will take out. Take it
Yes,
up.
Fine.
we'll come back at 20.
2:30.
230. 1.
FIR page 10 of it.
Page,
Page 10.
page 10.
10.
Yes.
Okay. I am the driver of the truck lorry,
Hmm.
and the battle launcher already recovered.
Hmm.
Battle launcher already recovered lorry. I have like the scissor list lorry. It starts from page 16 lorry to 23 lorry. All are scissor list lorry. From different person lorry, their battle launcher recovered lorry. In fact, I am no way connected with this case, but still I am behind the bar lorry. 15 days.
How many days?
15 days, 1.2. So custodial interrogation is either required or not to be decided.
We'll see the case diary in this case.
Not.
We'll have to see the case diary. How the driver is, I mean, heard Mr.
Yes, sir.
Sharma, the learned counsel, appearing for the accused applicant. Also heard Mr. MP Goswami, learned accused for the state. These an application of the prohibition of BNSS 2023. Paying for bail to the accused applicant in connection with the police station case number 178/2026 under section 61 in bracket 2 bracket small a stroke 316 bracket stroke 3 of BNS 2023. All for a CD, let the matter take on short again.
Well, 27 minutes.
27th.
It's in August.
August.
Apply.
Kalau tadi ticket up after some time.
Yes.
Sometimes similar with you.
Hmm?
The HR Chaudhary is here after some time.
All the time, I mean, you, one of the matter is,
Has to be called.
state, always you take time. Pass over.
Regular bail, my client in jail for 97 days. Let notice goes because there's
I
a.
heard Mr. P.J. Mahanta, the learned counsel, is
Can put me with-
preparing, senior counsel. This is the best solution for the accused applicant. Accused applicant also had Mr. MP Bishop and for the state. These are application under section 483 of the NSS 23. Paying for granting bail in connection with POCSO case number 26/2026 corresponding to Daythor Police Station case number 02/2026 under section 6/10/12 of the POCSO Act. Read with section 64(1)/64(2) in bracket small f /64 in bracket 2 bracket m /351 bracket 2 of BNS 2023. Read with section 75 of Juvenile Justice in bracket Care and Protection Act 2015. Full stop. All for the CD. All for the CD.
Notice
Matlab substitute
Oh,
case,
this is-
TCR may be called for.
Huh? This is a POCSO matter.
POCSO matter, TCR may be called for.
Search is filed.
Search is filed.
Okay. Registry to call for the TCR in connection with the POCSO case number 26/2026. Pending,
court.
pending,
Court of-
pending, from the court of the which court? Which court?
Karbi Alam,
Acha, special just POCSO Karbi Anglong.
Karbi Alam.
Notice to be, let notice be issued to respondent number 2 as per the prevailing notification issued by a prevailing notification of Government of Gauhati High Court. Notice to respondent number 1 is dispensed with since Mr. MP Goswami has put in his appearance. Later matter will be listed on
Matlab on matlab 7 matlab
7th,
not
7th of September.
September.
Okay, 7th of September. Mazat matter manalo.
May I please your lordship? Lordship, this is a regular bail application, lordship. Today we will 30 days behind the bar, lordship. 30 days behind the bar, lordship.
What is the FIR?
FIR page 10, lordship.
Page 10.
10, lordship.
Yes, yes.
Relevant.
Heard Mr. So-and-so, learned counsel appearing to the accused applicant, also heard Mr. MP Goswami. Then you write a reason application. Take it from here. Take it from here and call for the CD.
Not.
Let the matter be fixed on
On 28 matlab.
28.
This is a regular verification. FIR space number 13 also.
Okay, heard so-and-so.
Short date may be given, lots of forward lots.
Hmm?
Lots of short date may be given, lots of.
This
Nearby lots of forward police station.
this petition matlab did not deserve a short date matlab.
Hmm?
They did not deserve a short date. Lordship may kindly see in the breeze matlab newly constructed bridge.
Yeah, we always give short dates to people only. We
Yeah.
don't give.
Forward lots of.
No, we always give short dates. I mean, the bill has to be disposed of as early as possible. Heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard MP Goswami. Then you take it from here, listen application. Put it, you can take it from here. Call for the CD, let the matter be fixed on
Matlab 28 matlab.
2028.
28.
28.
Overless lots.
Also, can I seek for a short passover on behalf of Diego Goy? He's some legs and another goal.
Okay, pass over for time being.
Sorry, my lord, I was gonna ask.
Yes,
This case I have been told just now, CD might have been, sorry, charge sheet might have been filed. So let them make against it.
you
Yeah,
verified, we'll
I
take it up sometime
After later.
later on.
Uh,
When it will be comfortable to you.
2000.
Let it come tomorrow, madam, that is better one.
Tomorrow?
No.
Okay. You can list this matter tomorrow on the list on the prayer of
One is
the
that
joint
to get
prayer,
the
the joint
information.
prayer of the council, let the matter be listed tomorrow. That is that be there.
FIR is space 8 to 11, my lord.
Hmm?
8 to 11, my lord. Page number 8, my lord. My lord, the informant lost this FIR, my lord, after 2 or 3 days, my lord, from the date of occurrence, my lord.
Hmm.
My lord, after receiving an information from
One second. Yes.
my lord, after receiving information, my lord, from reliable source, my lord,
Mm.
the petition number 2 and along with others reporter of some news portal, my lord, went to a friend's dhaba at Sapaguri under Bongaigaon district to collect some news, my lord, where sex business against money was run by the owner, my lord. The place of date of occurrence was 28.
Who is the this thing? Reporter?
Reporter, my lord, uh, petitioner number was not present on that day of occurrence, my lord.
When he was present then?
My lord, I have stated in para number 3.
No. When, what about the other people? Who is the reporter?
My lord, petitioner number 2, my lord, Shohidul Islam.
He is the reporter.
The reporter, my lord.
Where is his identity card?
My lord, they, after receiving, my lord, I have not annexed identity card, my lord.
Heard Mr. What's your name?
My lord, S. Islam, my lord.
As Islam, the
Yes.
learned counsel appearing for the accused applicants, also heard MP Goswami learned AP for the state. There is an application under section 482 of BNSS 2023 claim for PRS bail to the accused applicants in connection with Kazalgaon PS case number 135/2026 under section 329 in bracket 4 stroke 308 bracket 1 stroke 308 bracket 2 stroke 356 bracket 3 stroke 35 of BNS. An FIR was lodged on FIR was logged on 37/2026 by the
337.
informant who is the owner of a dhaba, alleging that the accused applicants along with some three girls came to his dhaba and started behaving suspiciously. After certain objections, after objections raised, they went off, but later on they came back again and they came into the room of the cook and started touching him. And in the meantime, the persons persons who were accompanying him started taking photographs and videos. Later on, it was alleged that they started demanding money from the dhaba owner, that is the informant. So on receipt of the FIR, police registered Kolegaon PS case number, so yeah, 135/2026 under the aforementioned sections. Taking into account the facts and hearing the submissions made by the learned counsel appearing for the accused applicants, as well as the learned additional PP, this court is not inclined to grant any relief in this case. Accordingly, this instant AV application is dismissed. Next.
Sorry, my lord, I wasn't clear.
Yeah.
This is a bail application, my lord. Section is 69 of DNS, twice rejected by the trial court below, my lord. And there's a dispute, PS lordship will call for the CD.
Okay, heard Mr. D.
Short
Gogoi.
date, my lord.
Heard Mr. D. Gogoi, the learned D. Gogoi, the learned counsel appearing for the accused applicant, also heard Mr. MP Goswami, learned AP for the state. Then yeah, we take this reason application under so and so. All for the CD, let the matter be fixed on
26, madam.
26.
26. Oh, look.
Right, my lord, this is not PRS bail application. And my lord, the bail petition, my lord, filed by the petitioner against them, lordship will find at page, my lord, 11. This is, my lord, just post case to our case, my lord, filed by the petitioner. Page 11, lordship will find the case against the petitioner.
Bail কিন্তু বিচাৰিছে 238
Now, this is, my lord, case number, my lord, 238. 2026. Now, our case, lordship will find,
What? 572026 FIR was filed.
yes, same day,
Huh?
same day, my lord,
You also filed an FIR.
yes, lordship will kindly see our affair at page 15.
Hmm. Okay, we'll call for the CD at this
Look.
stage, huh? At this stage, we'll call for a CD and give a short date.
My lord,
Yes.
in the meantime, some
Huh?
extreme protection may be.
No interim protection, it's a, I mean,
It is a
Marpeat.
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 But our three people,
Yeah, I mean, the cross cases are there.
our three people small badly injured.
Okay, Mandal, I mean,
have also annexed the
we'll call
medical
for the
report.
CD and like, we'll give you a short date. We'll
Fine.
give you a short. But Mr. Mandal, the learned counsel appearing for the accused applicants also have MP Goswami. This is an
Yes.
application, then you write this, call for the CD, give a short date to
24 man
24. 24.
But may I bring my lord interim protection?
No.
Because all the sections are available except my lord one.
Hey, one
that
is
is
the danger,
also
one is danger.
Available, it can be my lord non-available also.
Yeah, which date you have given?
24 months 20
24.
after 1 week
24.
Obligation.
11.
Yes, Your Lordship. For anticipatory bail application, Your Lordship, the petitioner is the student of the Ayurvedic Medical College, Your Lordship. Lordship, the petitioner had a relationship with one ex, Your Lordship.
One?
I'm not taking her name, Your Lordship.
One X, yes.
Lordship,
One girl, one lady,
girl, Your
not boy, no?
Lordship.
Oh.
Lordship, and after the relationship turned sour, the relationship ended, Your Lordship. And every now and then she used to threaten him that he will lodge an FIR. And now what happened, Your Lordship? The police is searching for him in his comfort searching in his.
Where is the
house.
FIR?
There's no FIR, Lordship.
Then?
Lordship, I'm apprehending arrest.
You see, I mean, the girl is saying I'll file an FIR. I mean, then you will have apprehension. No, there is no
Report
nothing.
may be called for.
No.
From dispute PS, Your Lordship.
No, not required. I mean, only because has police visited your place? Has police called you?
Yes, Your Lordship.
When? You tell me when.
Lordship, I have mentioned, Your Lordship.
When?
Say,
You said that the FIR, she has threatened to file an FIR. Where is that?
Lordship, paragraph 6, Your Lordship.
Amended that law, so and so the petitioner inquired and found that no case is registered him till date, but there is reason like.
Paragraph 3 also, paragraph 3.
No.
The petitioner.
Nothing, madam, nothing will do. Nothing will do. Heard, no, nothing is there. There is no apprehension, nothing. You just drop of the head will come here.
And the petitioner states that the police person, peaceful police station are frequently calling the petitioner.
Or police person either avoided listener. But you have stated in there are contradictory statements you have made, then that means. The petitioner said that no notice of appearance so and so. However, the petitioner inquired and found no case is yet registered till him. So you yourself admitting there is no case registered.
But police is
Police is something doesn't matter. You go and appear. No cases because they cannot appear. I mean, arrest you without filing a case. So you have admitted yourself there is no case. Then where is the apprehension?
The only thing is,
No. Student or whatever. No. Heard MS so and so, the learned counsel appearing for the accused applicant also heard Mr. MP Goswami learned APP for the state. Reason application under section 482 of BNSS 2024, praying for granting pre-arrest bail to the accused applicant. Accused applicant, the applicant apprehending arrest arrest in connection with dispute police station case, dispute police station. So the learned counsel appearing for the accused applicant submits that the accused applicant is a student and he had a relationship with one lady and like the lady is threatening him. Since the relationship has gone sour, the lady is threatening him that she will file an FIR, file an FIR. It is the file an FIR. She submits the CVC police personnel is calling him and he is apprehending arrest. It is seen from the application that the petitioner has, the accused applicant has himself admitted that there is no case filed as yet before the police station on his inquiry. Taking into account the entire facts, this court doesn't find any merit in the instant case and the instant AB application is dismissed.
Oblige, your lordship.
Wait, please, your lordship. Lordship, in this case, lordship, what happened, this present petitioner, lordship, he is the victim of the circumstances. He has introduced this one minute folk, lordship, for lordship appointment of his son, lordship. My son already, lordship, got an appointment letter that was an fake, lordship. Since I introduced this minute lordship with this Kartik Borua, lordship, now police is searching twice my house, lordship, that I have stated. Prior to that, lordship, kindly peruse paragraph 2 and 3 of my petition, lordship.
Where is the FIR?
FIR is a non-FIR. May I pray for call for the report?
No,
from the
no
Mukal-
report, no report.
Lordship, Mukalmua police
No
station,
report,
because-
no report.
Because
no
lordship,
report.
police twice visit
No
my
report,
house. I
no
have
report.
specifically mentioned in paragraph 6 in my petition.
No, this has become a trend.
My lord.
For that, let's stop
FIR not-
filing.
Because
no
police-
report.
they are police are visiting.
No,
lordship,
no
they are
report. Police has not arrested you. Okay, fine.
arrested, but they have visited lordship without a issuing
What is
any notice.
the allegation? Why you have come?
Yes, lordship, paragraph 2 and 3 kindly peruse, lordship.
What is there?
Yeah, lordship, what happened? This petitioner, lordship,
See, I'll go with the merit. Okay, I mean
Yes.
no report. Let's see what is there.
paragraph 2 and 3, lordship.
What is there? That the petitioner begs to say that he has been cheated by one Kartik Borua, a son of so and so, who took money from the petitioner with an assurance to provide job to the sons of the petitioner at all India so and so. Thereafter, Sir Kartik Borua conducted fake online examination and thereafter provided jobs to the sons of the petitioner from so and so. The prisoner said that he was totally unaware of the fact of the appointment letter. Joining letters are fake one and rather believed it. He was overwhelmed that his son got job in the and Manu Haq, who is the resident of the locality, where the petitioner resides, by stating what
The fake job letter, lordship, will find on page 11 and page 13, lordship.
So you participated in the offense, right?
My son, lordship, got an appointment.
My son got an appointment letter, fine.
It
Then,
is, lordship, fake one.
then you introduced somebody to someone.
Since my son, I could not, lordship, before joining lordship, this petition, I have no knowledge because it is a fake letter, lordship.
You applied with against an advertisement.
No, lordship, that.
You
lordship,
have been told by someone that I'll give you a job, you give me some money.
Money.
You went there.
That, lordship, that is it.
Then-
That's why,
then-
lordship,
then-
say I am the victim of the circumstances.
What victim of the
Because,
circumstances?
lordship, he is-
What victim of the
falls in the
circumstances?
trap
You
of the Kartik
you are part and parcel of the corruption. You're
Lordship,
part and parcel of the offense committed.
He is.
You are equally liable. The
Lordship,
person
he
who-
fall in the trap of the Kartik Borua, lordship. That's why he introduced this, lordship, fake letter, appointment letter on page 13 also, lordship. This is the informant's son, lordship. He also got a fake letter, lordship.
Who is informant's son?
Lordship, Mafidul Haq, lordship.
Hmm.
Now, Moinul Haq.
Who is
against this-
Ashraf Ali?
Ashraf Ali is the present petitioner,
Who
lordship.
is he?
He's the father of the lordship, this Atikur Rahman, lordship.
Who is Atikur Rahman?
Atikur Rahman is the son of this lordship, present petitioner, lordship. Because, lordship, since I have introduced Kartik Borua with this minor,
You have lost all your skill of argument over.
lordship,
You said, I asked you Ashraf Ali, who is Ashraf Ali? You said Ashraf Ali, son of so and so. I said, who is he? You said, he is father of Ashraf Ali.
Ashraf Ali is the present petitioner, his son got an lordship, fake appointment letter lordship. And Ashraf Ali introduced Mainul Haq's son lordship.
Who is
And
Mainul Haq?
Mainul Haq is the lordship present petitioner who is after this petitioner lordship. Mainul Haq is the informant who is after this present petitioner lordship. Because I am suspecting lordship, police has visited twice because of certainly lordship, Mainul Haq insisted me to collect that amount from the Kartik Borua
Heard
lordship.
Mr. B. Chaudhary, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APE for the state. Is an application number 482 of BNSS 2023 granting for pre-arrest bail to accused applicant in apprehension of arrest. In apprehension of arrest in connection to a probable FIR to be lodged in Mukalma police station, Mukalma police station. The learned counsel appearing for the accused, appearing for the applicant submits that he is a victim of circumstances and he has been introduced by one person to one person who is into luring people and after taking money, giving jobs. Full stop. Yeah, he submits that the police has been visiting his place for inquiring about him. Therefore, he has filed this application. I have gone through the contents of the application and heard the submissions made by the learned counsel appearing for the accused applicant. After finding no merit in the case, the instant AV application is dismissed.
I live.
May I please your lordship? Lordship, this is an application under section 482 of BNSS 2023. Serious allegation has been leveled against me, lordship. Kindly see FIR dated 20/07/2026, annexure A, page 18 to 19, lordship. Where the allegation, your lordship got it? Page 18 to 19, annexure A. I will kindly read it out. Actually, what happens, lordship, the allegation is that on 19/7/2026.
We'll call for the CD in this.
man.
We'll call for the CD in this case.
Because I am a BCom student, one exam has been left, time to appear. So kindly protect me, lordship, and another
Exam is going on.
exam is knocking out the door.
When knocking on the door, when?
That document is not, but my identity card, all this.
No. Identity card is with the identity card.
That's it.
I mean, is the indication of examination.
No, lord.
Then
Because
when is the examination?
exam is, so far it has been intimated to me.
What examination the become student has?
Not back. In one paper.
So when is the examination? You tell me.
I think next month.
Next
think
month.
next
So there is
month.
lot of time.
Time.
I mean, lot of time.
My humble
Lot
submission
of
is that
time, Mr. I mean, we'll call for the CD and we'll fix it.
my humble
We'll fix
submission-
it in the next day, next
Right.
week,
Right.
next week.
I have two humble
Heard Mr.
submissions.
JP Das, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APE for the state. We'll give a short date.
Mine.
I mean, because serious allegations are there. So we'll give you a short date and we'll consider it.
Mine.
And we'll consider, no, see, we'll consider the fact that you are a student, you are having exams. Everything will be considered.
Lordship,
But I mean, till date, we are not giving you any protection. There is some serious allegations.
submissions may kindly consider, that is CCTV footage, so that we can, whatever.
He has been taken outside somewhere
No,
else.
Lordship, we know.
In that,
Hotel.
in the hotel, he has been taken.
So CC camera footage.
No, we'll see
From
what
the
it comes.
case diary.
Considering our movement.
We will see what is there in the case diary, then we'll consider, okay? Heard Mr. JP Das, the learned counsel appearing for the accused applicant. Also heard Mr. So-and-so, reason application, call for the CD. Then you write the date, when give a short date.
21st, my lord. Today is 13, my lord.
Today is 13.
21st, my lord. Was I?
May we appreciated,
20th if we will
Mine.
fix. This thing.
My
may I
20th.
kindly appreciated one more thing, Lordship, one humble submission.
No, tell me.
Because 183 statement has already recorded. of-
I have.
It will be.
We will consider the CD, then we'll decide. It's a case of rape allegation.
yes.
Correct?
Yes.
So
But
don't insist,
I-
don't
I-
insist must, don't insist must. Okay?
Lordship, I love this, I love.
BRS bail application, my lord, the allegation lawsuit will find at page 17, the operation proposal at page 21, my lord. Page
Hmm?
21, the
21.
21, the operating portion, my lord. This is the FIR lodged by the apartment, my lord. For the,
1 second. There was another case,
yes, already interim.
huh?
Already interim has been.
Interim
granted.
has been granted,
Yeah,
right?
That is, I have annex, my lord. That is at page 38, annex 2.
Please.
38, my lord. Operative portion 39, para 6. Accordingly, it is provided that in the event of the arrest of the accused prisoner, his health-
Yeah, you are for, Vitali Saikia.
Vitali Saikia, my lord.
Okay, right. Heard Mr. So the land council appearing for the accused applicant. Also heard Mr. B. Sharma, land appeal for the state, is an application under section 32 of BNSS 2023, praying for granting pre-arrest bail to the accused applicant in connection with the legal PS case number 40/2026 under section 316(5) of BNS 2023. 2022. The case relates to misappropriation of post office savings. Post office savings account by the accused applicant along with certain other persons. Yeah, the learned counsel appearing for the accused applicant submits that other courts have been already granted interim pre-arrest bail by a coordinate bench of this court that order dated 24/6/2026 submits that he is willing to cooperate with the investigation and therefore some interim protection which should be granted to her. After considering the matter in its entirety and taking into account that the other co-accused persons have already been granted interim pre-arrest bail, the accused, it is directed that in the event of arrest of the accused applicant, she shall be released from interim pre-arrest bail. Interim pre-arrest bail on furnishing of bail amount of rupees 20,000 with a security of like nature, such to the satisfaction of the arresting authority, subject to the condition that the accused applicant shall appear before the investigating officer within a period of 7 days from today and shall cooperate with the investigation. Call for the CD and let the matter be fixed on 27/7.
Already over, man.
Already over.
Already over.
What happened after 27/7?
27, my lord, my lord, CD was not available on that time, my lord.
Hmm?
CD was not available.
It was not available.
Not available. Then another case, 18 is fixed. Another case is 18 of this month is fixed. And this next date has been given, I don't know. First case,
18 this month.
18 this month in another case, my lord. That is that.
Okay, let the
But,
matter, okay, then we'll fix another, I mean, let the matter be fixed on when?
Minor. From Dibrugarh, Malan. That may be on 27th, Malan.
27th.
Malan.
All right.
My submission is in Malan. Case there may be call for Malan. That is
Yes,
27.
we have called.
Malan. 27 Malan.
All right.
In previous lordship, 482 application, your lordship. The allegation against the petitioner is that in his microfinance group, your lordship, the informant has invested some money, but that has not been returned to him. Lordship, it is a very vague allegation, your lordship. Lordship will kindly find the FIR page 8, your lordship. May I read the FIR, your lordship?
Yes.
Okay, sir, with all due respect, I beg to state that the aforesaid accused person together started a group named Lotani Saporil Milan Seva Sansoy Homobai Committee and set up a system for depositing money and providing loans. In the said group, on 18/12/23, I have fixed an amount of rupees 2 lakh for a period of 1 year. now in 2026, and the tenure of the fixed deposit expired. When I went to claim the fixed deposit money, the accused person made various excuses delaying the matter by promising to pay today or tomorrow. On last 2/3/2026, when I went to the office of the cooperative society to demand the money, the accused person kicked me out of the office and threatened to kill me if I ever came back to demand the money. Your Lordship, in this FIR, Your Lordship, no details of what is the account number and nothing.
Do you need to write an FIR like a William Shakespeare's novel?
No, Lordship, but
You know, sufficient details have been
pertains to
given.
document,
Sufficient
Your Lordship.
details
It
have
is-
been given.
and based on documentary evidence, Your Lordship. Moreover, Lordship, the case under which it is registered is also below 7 years, Your Lordship, and office is mandatory, Your Lordship.
We'll see the
Right.
case then.
Everything based on.
We'll see the case
Your
then.
Lordship.
Madam.
Heard MS so and so the council appealing for the accused applicant also heard Mr. B. Sharma, lawyer, APB for the state. APB for the state, and then you write this is an application under so and so, all for the CD, let the matter be fixed on 25th,
Madam.
25th.
Oblige, Your Lordship.
These things are happening each and every corner. I mean, these people are cheating people.
Lordship,
Normal
but
people.
why? I'm ready to cooperate, Your Lordship. Oblige, Your Lordship.
Ready to cooperate is another thing.
Next thing.
Lordship,
Yes.
this is a discrete bill application and the edit sections, sections comes under tax and criminal justice. Lordship, the.
What is the FIR?
Is in page number 22, annexure B.
Is number 22.
Yes, Lordship. May I read the file?
Yes.
With due respect, the informant most humbly and respectfully begs to submit as follows, that informant is a business person, is resident of above mentioned address, that for a long days, the informant is supplying waste product to different companies of West Bengal. Accordingly, on 29/6/2026, the informant has supplied 31 ton waste to Rajesh Chanwar, 89 Netaji, Subhas Road, second floor, with number 1, Kolkata, GST hearing number Swexor, West Bengal, for an amount of rupees 6,35,500. That he had supplied the said product for his godown situated at Boralimari under PS, Guragaon, the district of Morida, Assam. That informant has supplied and delivered the said product to a registered vehicle on AP 39 WV 4887, authorized by Narayani Transport, Hoibergaon branch, Nagaon, Assam, through Ajoy Roy, and accordingly said transport took an amount of rupees 20,000 in advance from the informant. That the said vehicle was driven by above mentioned 3 drivers accused, and accordingly the above mentioned accused had put all products of the vehicle on the way nearby Patiyar Toll District, Kokrajhar, and kept the said vehicle angry. The accused committed theft by criminal conspiracy for which the
Yes, yes.
Madam, let's make call for CD here.
Lordship, at this stage, my only submission is that the petitioner apprehension is that he is the owner of the vehicle. He is not accompanying the vehicle from Morigao, from Assam to West Bengal. Also, Lordship, apart from the.
No owner accompanies the vehicle because he has, I mean, appointed a driver and driver is supposed to carry. He is not going to accompany the vehicle.
Lordship, fire, there is no material to suggest.
Okay, we'll see what is there in the city. Okay. But MS also the learning council appearing for the accused applicant also heard Mr. B. Sharma. Then this is an application call for the CD. Give a date.
26.
Yes.
This is an application for 3 years bail, my lord. Here no FIR was lodged, the GD entry was made, my lord. On the FIR was lodged, no case was registered. Annexure A, my lord, is the notice, my lord, at page 10.
Yes.
So this notice was issued to the petitioner, but petitioner has an apprehension. If he appears, he may be arrested. So that is why he is praying for 3 years bail, my lord. And in fact, there is a dispute between 2 brothers, my lord. His own brother, my lord, lodged FIR against him. And he also lodged again, my lord. Cross case is also there, my lord. A civil dispute, my lord, was going on between both the brothers, my lord. The family affair.
Case hasn't been filed.
Case has been, my lord, FIR
Lordship, page 10, my lord. They were called only for
GD entry was-
preliminary inquiry relating to a complaint received from his at this police station, my lord. Only for preliminary inquiry.
An apprehension, my lord.
I mean, then how the police is going to do inquiry? If, I mean, the purpose of this notice will be diluted, or diluted means what negated? If the court gives, I mean, bail to these people only in the basis of the inquiry. Okay, let let her face, I mean, when some protection should be given. Right, the MS so instead of and counsel of the accused applicant also have Mr. B. Sharma, Leonard APU for the state, is an application under section 42 of the NSS 2023, paying for grant of PRS bail to the accused applicant in connection with Charmari PS GD entry number 2 number 26. 26. Who has been given this thing, notice?
Three petitioners, my lord.
All have been given
My
notice.
lord, husband, wife and daughter.
And this has been, FIR has been filed by whom?
By the my lord, brother of petitioner number 1.
This is filed by you.
Yes, my lord, this is a cross case, my lord. The FIR filed by his brother is not available, so I have not any.
Anyway, the learned counsel appearing for the accused applicant submits that there is some friend there. Who are the, I mean, other parties? Other parties means like they conflict with the other party. Who has filed the other affair?
Complaint is his brother of petitioner
So
number
family,
1.
within a family. Within the
Within
family.
the family, yes.
There is a dispute within the family. And therefore, the accused applicants as well as another person. What is his name?
My lord, the name of the informant is Sirajul Haq Chaudhary.
Another person, Sirajul Haq, filed their respective FIRs, but none of the FIRs have been registered as yet. Though GD entry has been done by the Chanmari police station. She submits that, Learned Counsel submits that a notice for appearance has been issued by the Chanmari police station to the accused applicants, to the accused applicants, and therefore they are apprehending arrest. She submits that they will cooperate with them in the investigation. Cooperate with the investigation and appear before the inquiry officer, but they should be protected. They should be protected at this stage, taking into account the entire facts of the case. This court should reserve the considered opinion that the accused applicants can be granted intrinsic granted some protection at this stage. Accordingly, it is directed that in the event of arrest of the accused applicants, applicants in connection with GD entry number 26. 26 of what? 26?
GD entry number, my lord. GD entry case number.
26 dated 17/7/2026.
Yes.
The 26, the accused applicant shall be released on bail, on pre-arrest bail, on furnishing of bail bond of rupees 20,000 each, subject to the satisfaction of the arresting authority. subject to the condition that the accused applicants shall appear. mm,
Hmm?
Shall appear before the investigating officer of Chambari police station within 7 days from today. Number two, that the accused applicant shall cooperate with the investigation. Accused applicant shall not tamper or hamper with the investigation. No, that sentence is right. In terms of the aforesaid direction, the instant of the application is disposed of.
Disposal.
Right, yes. Yeah, please, Lordship. Lordship, Tesco PS case number 470, 2026, under section 69 of PNS. Lordship.
FIR.
So we call for the CD in this case.
Lordship, same protection. Yeah, I was in love with her.
Heard,
since
Mr.
2 years.
Mr. Your name?
Evolvement, Lordship.
A. Bourbon. What do you want to say?
I was in love with relation with her, Lordship, since 2 years, not 5 years, Lordship.
Mm.
One thing is there, say, case number 21 FIR, Lordship,
Mm.
informant told that, may I read, Lordship?
Yes.
ইয়াৰ দ্বাৰা আপোনাক জনাও যে 5 বছৰ ধৰি মোৰ লগত প্ৰেমৰ সম্পৰ্ক অব্যাহত থাকি ৰূপাঞ্জল বৰঠাকুৰ নামৰ ল'ৰাজনে মোৰ লগত শাৰীৰিক সম্পৰ্ক কৰাত মোৰ অন্তঃহত্যা হৈছিল। তাৰপিছত সি অন্তঃহত্যা ঔষধ খুৱাই নষ্ট কৰে। তাৰপিছত ৰূপাঞ্জল বৰঠাকুৰে মোক 1/4/26 তাৰিখে স্পেচিয়েল মেৰিজ আণ্ডাৰ এক্ট 1994 ফৰ্মত চহী কৰিছিল। মোক প্ৰলোভন দিছিল যে মই মোৰ অন্তঃহত্যা নষ্ট কৰিলে সি মোক বিয়া কৰাব। মোৰ হাতত সি খোৱা MPP কিট আৰু ব্লাড ৰিপৰ্ট আছে, লৰ্ডশ্বিপ। Prior to the 1/4/2026, Lordship, she WhatsApp me the information. WhatsApp me at suicide note, Lordship. I have it next here. That
Subsequently, she died.
here, page number 32, Lordship. She told me that
She expired or?
information. Yeah, so
She
many.
expired.
Expired, Lordship, subsequently. Subsequently, page 32, Lordship.
32.
She
Yes,
expired.
yes,
CD will be required, Lordship.
Lordship, she every time you keep telling me, Lordship, no doubt I love the relationship with her since 2
No,
years, not 5 years, Lordship. She used to take
Heard so and so.
Chief Minister Himanta Biswa Sarma, Lordship.
Heard so and so.
He always his social media in say always take with Himanta Biswa Sarma Chief Minister, Lordship, and she try to threaten me, Lordship, lots of time, Lordship. And even I sometimes when we are in love relationship, financially
Heard so and so, then is an application. Then you write, call for the CD, let the matter be fixed on. When
28, Lordship.
28.
Very clear. 19 and 20 out of same FIR, Lordship.
Hmm.
FIR is at case 15, Lordship.
Page 15.
15, Lordship. Married, Lordship.
Hmm. Heard Mr. Poddar, Learned State Poddar, Learned Council, appearing for the case applicants. Also heard Mr. P.S. Clarko, Learned APB for the state. This is an application, you write, call for the CD, let the
Lordship,
matter be fixed on.
Interim bail, Lordship. So the
No
one is Oman,
interim,
Lordship.
no interim.
One is Oman, Lordship.
Let it
We
be
have no
Oman.
tractor, nothing to sell, Lordship.
No. And what about the other one?
It's same FIR, it is for the case number 3, Lordship.
Okay.
Another is 2 for 2 and 4.
No interim.
On 28, Lordship.
No, 28. 28.
Lordship.
28.
One Oman,
Both are the same.
because I have only 1 6-month child.
Omen, I mean, I don't want to make a, I mean, this thing, general comment, but like, they're equally involved.
Lordship.
There is no difference because they themselves claim that they are equals. So what is the specialty?
Please, your lordship. Second time bail application, lordship.
POCSO is there, lordship.
Lordship, respondent is present.
Second
Second time bail application, lordship. Page 12 is the last.
When last rejected?
Last rejected on 14/7, lordship, and after that they got married, lordship. Lordship, when the FIR was filed,
They got married.
lordship,
Where is the marriage certificate?
lordship, I have annexed on page 15, lordship. They have socially married, then made an agreement and then applied for marriage under Special Marriage Act, lordship. When the FIR was filed, she was 17 years, 10 months, lordship. After attaining 18, lordship.
This case came earlier.
Yeah, lordship, yesterday, the father of the petitioner got bail, lordship, before your lordship. And today today is the accused number 1.
That case, lordship, on that day, lordship, on the same day, lordship, they appeared, lordship.
I am for the victim.
Mr. Locker, what is to be done? I mean, the case will go on. I mean, as far as this thing is concerned, they are staying together, married. But they married with the acknowledgement only.
After that, lordship, one agreement is also done, lordship.
Hmm.
And socially got married, one photograph also, lordship. I have an express 16, lordship.
It doesn't look like any marriage photograph.
Lordship, lordship.
So where is the headgear?
At page 18, this agreement is also done between the parties, lordship, and they have settled the matter amicably and living as husband and wife, lordship.
But lordship,
And in the last rejection order also, lordship, I have submitted that they are going to amicable settlement is going to happen, lordship. In page 14, lordship. After that bail was rejected because as that stage.
on 14/7, lordship, there was no any marriage, lordship. But on the today, lordship, after 1 month, not after 1 month, that marriage has been solemn.
Marriage has been done.
Marriage solemnized on August 4th, lordship.
August 4th.
This one.
Page 15,
Apply for
lordship.
special marriage.
Lordship, this is application for special marriage, lordship. Also, lordship, let the city come because, lordship, if they have also done some Kazi marriage, then also, lordship, something they could show, lordship. Nothing has been shown, lordship.
One agreement is also there, lordship.
Only
Page
agreement that
17.
will not work, lordship.
Page 17 between Rakibul and Saklina, lordship. They have got married, nothing else, lordship.
ऐसा है good. ऐसा case क्यों ना होते? पुणे दिस में जाओ.
Okay, let them go, Mr. I mean, the case is
They
there.
have
Let
amicably
the case.
settled the case, lordship. In that case, Lord, section 22 would come against them, lordship, because, lordship, in
You
POCSO case.
proceed with it. I mean, we are just giving this thing only. We are just giving him the protection of protection from marriage. Otherwise, your liberty, because they are staying together now. They are saying, yesterday, father-in-law was given bail. With this. Heard, Mr. What is his name? Yes, Ahmed.
Why I am submitting, lordship? Why I am submitting? On the same day they are appearing, lordship, and today, lordship, when they have filed this application, if the marriage is solemnized, lordship, in any way, lordship, if they are solemnized as per their visuals,
Allegation is by whom?
lordship.
Allegation is by whom? The informant. Informant is who? This is the person who is standing beside you. He is saying that like both the parties have got married now. He doesn't have any objection. And in that case, what is to be done? Your case, I mean, if you have some this thing, the case will go on. And in the case, I mean, both are measure.
Both are measure, lordship.
Both are measure.
After attaining 18, they got.
And your this, I mean, the other case, trial court, I mean, trial court also, there is no purpose going on after this thing. Heard Mr. J. Sam, counsel appearing for the accused applicants. Also heard Mr. P.S. Lockhart, appearing for the state, as well as Mr.
K. Islam.
K. Islam, government counsel appearing for the informant.
Victim.
Yeah?
Victim.
Informant, you are not informant.
Victim, lordship.
Informant is who?
My father.
Your father. Okay. For the victim. Reason application number section 482 of BNSS 2023. Paying for grant of PRS bail to the accused applicant in connection with Howley PS case number 39/2026, registered under section 173 in bracket 2 of the BNS 2023, read with section 4 of POCSO Act. An FIR was lodged on 11/4/2026 by the respondent number 2 before the Howley police station, alleging inter alia that the respondent number 2's daughter, namely XX aged about 17 years, 10 months, was proposed by the accused applicant.
Cause this condition.
By the accused applicant on several occasions for a relationship and harassed her mentally. Semicolon, that when the informant's daughter refused the proposal of the accused applicant, he started threatening her. Semicolon, that on 26/3/2026 at about 3:30 p.m. While his daughter was returning from shopping from Khandakar Para market, on the advice of the father of the accused applicant possibly took her in a Maruti car, and after reaching Howli Sareli, put her into a bus and took her to Johar. Semicolon, that the accused applicant took the informant's daughter to a hotel in Jorhat and committed rape on her. Semicolon, that on the next date, it is on 26/3/2026, the accused applicant put his daughter on a bus and sent her to Howli. On receipt of the FIR, police registered the Howli police station case for 39/2026 under the aforementioned section. The learned counsel, appearing to the accused applicant, submits that after the incident, the girl has resolved all her issues with the accused applicant and his families. It is also submitted that both of them, it is also submitted that both the boy and the girl, have already applied for registration of their marriage, marriage, which was acknowledged by the authority by issuing an acknowledgement application. Acknowledgement dated 4/8/2026. If the learned counsel further submits that then an agreement has also been entered into between the girl and the boy on 4th August 2026, whereby they have agreed, they have declared to be married to each other. And when did you perform your marriage?
On 4th, Your Lordship.
4th, you have, this is the agreement.
Yes.
Then you said that, both shall perform their marriage before the registrar. So and so. Agreement, otherwise
For
agreement-
registration, it takes 2 to 3 months. We have
No,
to-
your social marriage you said, na?
Okay.
So when is the social marriage happened?
On 4th, Lordship.
Your Lordship, 3rd August evening, social marriage is done.
Oh, sorry,
In front of the
3rd.
party, and the next day, it is applied for registration.
Okay, this so means that social marriage also happened on 3rd of
Yeah, why
Uh,
not? Yeah.
3rd August,
হয়েছে।
3rd August, and they have executed an agreement for marriage also on 4th August 2026. He submits that since the couple has been staying together as husband and wife, the accused applicant should be granted bail. Mr. So the learned counsel appearing for the victim has also stated that they have got married and applied, they have got married socially and applied for special, applied for marriage under Special Marriage Act. So, taking into account the entire facts of the case, and and in consideration of the submission of the counsel appearing to the respective parties, this court is of the considered opinion that the accused applicant should be granted arrest bail accordingly. It is directed that in the event of arrest of the accused applicant in connection with all the PS case number Only PS case number 39/2026, the accused applicant shall be released on bail on furnishing of the bail bond of 30,000 with a with a with a severity of like nature, subject to subject to the following conditions, like his applicant shall cooperate with the investigation, cooperate with cooperate with the cooperate with the investigation. Cooperate with the investigation. Shall appear before the investigating officer within a period of 7 days and shall cooperate with the investigation. In terms of the officer, the incident application is disposed of as allowed. We'll come back in 5 minutes.
There are 3 witnesses, Lordship, victim and 2 other independent witnesses, and the investigating officer, as part of the search report. The major allegation is abduction for ransom and rape, Lordship. And charges has been framed
And
rape, Lordship. And charges has been framed on gang rape, Lordship. Now, Lordship,
yes,
the allegation of abduction for ransom and rape, as per my understanding, will not sustain, Lordship. If Lordship will come to the statement of the witnesses, if I may come to the section of 140, Lordship, for kidnapping for ransom, Lordship. In FIR, there are two part, Lordship, where she has stated, the victim has stated that she has been raped while she has been taken away in a car, and the other allegation is, Lordship, she has her necklace has been taken, and the person, there are 3 persons, 2 persons are on bail. They have got default bail, and present petitioner who is in custody. 1 person is there who is Sahidul among this accused person. To his account, they have asked for money, and 20,000 has been transferred. Now, Lordship, victim, as per the FIR, the amount, victim says that the amount has been transferred by one Nurzul Mondal. In the FIR itself, it is there in third para, Lordship. And if Lordship comes to the statement of one other witness, who is Baharul Islam, he says that he has transferred the money. As per the Baharul Islam statement, Nazrul Islam, the other witness, he says that Rasida's brother Sahid made statement. As per their statement,
only you are saying that there is some discrepancy
There is
about
discrepancy.
transferring the money.
Yes.
Who has transferred the money?
Yes, and in that case, Lordship, kidnapping for ransom will not come, because there is a major discrepancy is there, Lordship. And Lordship, the FIR, Lordship, FIR.
As far as the rape, what is there?
Yes, Lordship. The FIR, the incident took place on, Lordship, 3rd of June 2025. The FIR was lodged by the victim on 17/6/2025. There is delay of 14 days.
She was abducted.
Yes, and Lordship, but in the FIR itself, she has stated that she was again she was left, Lordship, in the place from where she was abducted, Lordship. And the case was registered after some 34 days, Lordship. And Lordship, if Lordship comes to the search sheet, Lordship, the police has she has denied for the medical, Lordship. She has denied for the medical, and there is no there are absence of, in the search sheet, Lordship, there are absence of corroborative forensic and biological evidence, Lordship. And Lordship, no physical injury mark has been, is the gang rape application is there, Lordship. No physical injury mark the IO has there in the search sheet, Lordship.
In the PM report, what is there?
No,
She is alive.
she's alive.
She is alive.
She's alive.
Sorry,
but
PM, I'm saying medical report.
medical, but she has refused medical.
He has
She
refused
refused
medical.
medical.
Refused medical.
In the IO,
Earlier 183 statement not available. Now it is available, madam. I have flag mark, madam. There, Lordship will find how she was kidnapped and therefore tortured for extortion, money taken away from her, and thereafter gang rape, my lord. This is her statement 183.
yes. Other witnesses, Baharul Islam and Nazrul Islam, are also there, Lordship. IO has relied upon no documents as per the search sheet, nil. List of article, material, object relied upon, nil. Neither the witnesses nor the victim has relied on if the payment was done online, there is no record has been submitted. Result of laboratory analysis, expert opinion, medical examination, nil logic. Neither any mark of force lordship has been determined by the IO in the search sheet.
One thing, my lord, may I submit, my lord? He has mentioned in the morning, my lord, that she is not going to appear for the informant, my lord.
Oh.
I
what happened
mentioned
now?
in the morning for withdrawal of my wakalatnama. Thereafter, I took instruction from the informant. Now she told me that she doesn't want to proceed further and she doesn't intend to engage any other counsel in this case, Lordship.
He doesn't want to engage anyone.
So nice.
Statements are clear. She has been raped.
Her statement, Lordship, and other,
Her other people's statement also.
there's a statement.
Other three
Other
persons were
co-accused.
there.
Other accused.
All have stated that rape was committed.
That will not be admissible in the trial.
Their trial will say, you argue all these things before trial court.
Co-accused statement will not be admissible.
You argue before the trial court. Trial has proceeded now, you argue before the trial court. It is
Yes.
not a case where trial hasn't started. Trial has
Right.
started, you argue before the trial court.
Lordship, the accused behind the bar.
Mr. D. Mehdi, the learned counsel appearing for the accused applicant, also for Mr. M. P. Goswami, learned APP for the state. MS, what's your name?
Bora, Lordship. Miss D. Bora.
D. Bora, the learned counsel appearing for the informant. Submits that she has been instructed not to appear in the instant case anymore. This is an application under section 483 of BNSS 2023, being for granting bail to the accused applicant in connection with sessions case number 73/2026 arising out of particular case number 126/2025 under section 140 in bracket 3/304 bracket 2 /64 bracket 1 at BNS 2023. An FIR was lodged on 17/6/2025 by the informant alleging inter alia that she was called by an unknown person by one mobile number. She was called by an unknown person by a mobile number to discuss for certain work. It was alleged that when she was picked up by three unknown persons in a white car and traveled through Alexander Masjid, visible surveillance, Anka, Bakra, Bhalibal, Boko, Dharapur, and during this time, and during that time, the informant and victim are same,
Yes, yes.
Informant was taken by knife and she was possibly injected something. It was alleged that thereafter she was raped by the accused applicant along with other two accused persons. It was alleged that she was forced to call her brother to send some money amounting to rupees 20,000, and the same was also paid to one Sahibul Islam one of the co-accused in the instant case. On receipt of the FIR, police filed, police registered Fatima case number. 1262025. After investigation, police filed a charge sheet and the matter is now pending for pending in the evidence stage.
Evidence.
Pending in the evidence stage. Full stop. The learned counsel, the parent of the accused applicant submits that the allegations made in the FIR are totally false and no case of abduction has been made out in the instant case. No case of abduction.
Sorry, Lordship.
No case of abduction is made out in the instant case.
Yes.
Right? Abduction in the instant case. And he submits that the FIR was filed delayed, FIR was filed belatedly after the incident and the victim had refused to undergo the medical examination also. He submits that, how many witness examined now?
No,
Not a single
not
witness.
started, my lord.
They haven't started.
Not started.
The 3 witnesses are there only.
Only 3 witnesses or someone?
Only 3.
Only 3 witnesses are.
He submits that.
No eyewitnesses.
He submits that no eyewitnesses are involved in the no eyewitnesses involved in the instant case, as well as 3 witnesses are also co-accused. The witnesses are co-accused.
No, Lordship.
Hmm?
Lordship, one is the victim statement. Other 2 are the brothers.
Not 2 other brothers, witnesses.
Yes, sir.
And what about the co-accused?
Co-accused statement will not be admissible, Lordship.
No, I'm saying whether how many co-accused are there?
2
2 co-accused, my lord.
2 co-accused persons are there.
Yeah.
I mean, now nobody has been examined.
Nobody has been examined. Because, my lord, charges were framed on, my lord, 19-6. Thereafter, 31-7 was fixed for evidence, my lord. 31-7 last.
31-7, nothing happened.
31-7 perhaps because because it came earlier, my lord. Records are earlier.
Nothing
Records came earlier.
Earlier.
happened. Instruction.
Your instruction, nobody examined.
Yes, Lordship. Nobody examined.
He submits that those charges have been framed, nobody has been examined till date. And therefore, the accused applicant should be granted bail. The TCR in the instant case has been received. The learning EPP and the other things submits that there are sufficient implementing materials against the accused applicant of his involvement in the offense, so narrative in the FIR. Therefore, he opposes the bail application. It is seen that charges in the instant case has been framed on. Charges framed on
Charges framed.
Charges
when?
framed on 19-6.
19/6/2026 and date has been fixed for appearance. It is also seen that how many witnesses named in the charge sheet?
4 witnesses.
Total 4 witnesses along with the
Along with
investigating
IO,
officer,
my lord.
investigating officer.
It is also seen that only 4 eyewitnesses have been named in the charge sheet. Charge sheet. Taking into account the fact that the charge has already been framed and trial has already begun, this court is not inclined to grant any bail at this stage. At this stage, as the trial is expected to be completed soon. Rejected.
Deeply obliged.
Right.
Already TCR has been received, my lordship. We have taken step by
Step 1, I know.
Hmm?
But I could not find that whether steps were taken or not, ma'am, because there is no office note.
reflected on the.
Not reflected in the office note, ma'am.
Post title of the High Court display.
No steps have been taken.
Already taken, what in,
But here it is not there in the record.
It's not recorded.
not record, no. But it's showing in the display in the post title of
You
the.
find out in Go and verify. Okay, sir.
Step my lordship, always some witnesses are examined.
Your name, Lala. Your name?
Arbegam.
R. Begum. Or Ms. R. Begum, or I am
Yes,
also
we got it.
appealing for the accused applicant, also want to show and appeal for the state. This road doesn't, this road, at least note Yeah, does not reveal by taking steps. Therefore, service of notice upon respondent number two. Respondent number two. How, you have taken steps.
Already taken a step.
How the learned counsel according to the accused applicant submits that she has already taken steps for service of notice upon respondent number two. Registry to verify and list the matter after such verification.
But if you in the meantime, some witnesses are examined, so kindly allow some time to file additional evidence. Already their statement are recorded in the.
Learned counsel is allowed to file an additional affidavit bringing on record the statements before the statements of witnesses before the trial court. Let the matter be listed when 9th of September.
May I please, your lordship, lordship, case diary is not available in the court, lordship, it's
Case diary is
Yes, they are not available, madam.
case diary is available. Let the matter be listed after. Let the matter be listed.
lordship, one of humble prayer before this law, court, lordship.
Matter be listed on-
Lordship,
On-
a formal direction may be given to the opposite party to produce case diary on the next date, lordship.
On 2/9, madam.
Lordship, a short date may be given, lordship.
No, we are giving formal direction only. Not informal direction. Let the matter be listed on 20,
Lordship, 19, lordship.
let the matter be listed on 27th of August.
Lordship, short date,
27th.
19 or 20, 19 or 20, lordship.
A lot of matters have been listed.
In this case, TCR received lordship. And case is in evidence stage lordship. No witnesses examined till date lordship.
What, so matter?
Lordship.
What matter?
This is date case.
Matter relates to
Date case lordship. Murder lordship.
murder.
Murder of the husband lordship. Brutal murder lordship.
Yes.
Already, my lordship, already 6 prosecution has examined 6 numbers of witnesses out of 14. So my petitioner being a lady, there is no scope of her tampering any evidence nor to influence the witnesses by any manner.
Ladies can murder, but ladies cannot influence the witnesses. How many are there? How many witnesses together?
Pardon?
How many witnesses are all together? How many witnesses?
14.
14. Six
Six.
already
6 already completed
completed.
and she has passed already about 2 years, 1 year, 11 months. Her father is ailing, he has a prayer, he has a prayer
Fine.
for taking her father to organ transplantation.
Father,
So, Calcutta.
Record does not reflect any prosecution, any witnesses.
That will be submitted.
Record does not reflect any examination of witnesses.
check.
Yeah, witness গুলো আহা নাই রে ভালো।
She has only a younger brother only. One younger brother, father and mother.
The younger brother can take care.
But he has no any opportunity to do this. She have to
But-
help her, help him.
No, he can also do it. How old is he? I think more than
Details I
20,
don't know.
I think more than 20 years.
Oh, yes. I'm from legal aid cell, so all the data are not available to me.
Mr. Lockout, 2 years and 11 months, lady.
Lordship, here in this case,
Here
Lordship,
is fine.
Lordship will find Lordship how brutal murder,
No,
brutally she has killed Lordship, her husband Lordship.
Litigant-
And
whether her detention is required till the trial is completed.
Required, Lordship, because her intention, her act is like that, Lordship.
Mm.
When she killed her husband in such a way, Lordship, and apart from that, Lordship, her minor son is the witness, Lordship.
Daughter,
Daughter,
is
Lordship.
8 years old.
She is 8 year old, Lordship. So, Lordship, that she has also given her 183 statement, Lordship, at that time, Lordship, and she has given she saw everything, Lordship. So, Lordship, at this stage, Lordship, let the evidences be completed, Lordship, because, Lordship, she may influence anyone, Lordship.
Lordship, it is not yet finalized that she is the murderer. He is accused, no doubt. But it will be known after the trial. has
Only
been
the declaration is required, Lordship, that is not given, but, Lordship,
completed. So this opinion is not correct, I think.
and the witnesses part are not come here, Lordship. Evidences are not come, Lordship.
I have submitted.
You know how about the
In
evidence?
the petition I have submitted. Those are the,
Court is it?
those are the record.
আপনাকে বলে 6টা উইটনেস দিছে
Oh, so now I have collected from the trial court people.
record does not reflect, Lordship, that witnesses are examined, Lordship. A report may be called for, Lordship, because, Lordship, here, Lordship, no witnesses evidences has been sent, Lordship, and apart from that, Lordship, the orders, it does not reflect that evidences are what, Lordship. I have not found, Lordship, here.
Yesterday I have asked the advocate there in the trial court. He informed me. Oh, maybe it was sent earlier. Maybe it is sent.
Okay, we'll call for the updated,
Lordship.
updated,
And status report may also
Is here.
call for, Lordship.
then we'll see what has happened.
Lordship.
Okay, heard Mr. B Das, the learned counsel, learned legal aid counsel appearing for the accused applicant. Also have Mr. P.S. Locker, learned APE for the state. Mr. Das submits that subsequent to filing of this instant bail application, 6 witnesses have already been examined before the trial court. Full stop. The trial court record has been produced before this court. However, this court could not find any of the statements available in the PCR. Accordingly, the registry is directed to call for the updated trial court record, scan copy of the updated trial court record. From which court? From the court of sessions,
Additional session judge, Dibrugarh, Lordship.
additional session judge, Dibrugarh.
হয়নি?
Additional session judge, Dibrugarh. Let the matter be fixed. 28 August. 28
Or
August.
first week of
First week of September, yes. Let it be on
28th August, okay.
10th of September.
Yes.
It will not reach the updated schedule. 10th of September.
38, 39.
My lord, here we have received the case there, my lord. But final opinion is yet to be received, my lord.
What final opinion?
My lord, it was sent for DFSL for conclusion, my lord. In the PM report, it was not decided, my lord, cause of death.
So
Yeah,
DNA is not, DNA received, DNA is not received.
not received, that's why, my lord. I pray for short death, my lord, 1 week time, my lord.
But Mr. J. Ahmed, the learned counsel appearing for the accused applicants also held. Mr. Mr. B. Sharma, the AP for the state. Mr. B. Sharma submits that though the case that is available, the DNA report is yet to be received.
My lord.
Yet to be received. Let the matter be listed. When?
My lord, next week, my lord, 24th, my lord.
20, let the matter be listed on 24.
I'm preparing for Malan informal.
Mr. So and so is
Take care,
appearing- is appearing for the, is present for the informant.
My lord.
In
Item number.
interim order.
In item 39, my lord,
Uh,
one interim order was granted to my lord, petitioner number 1, my lord,
okay. Write the same thing. Same
only
thing,
for 1 person.
Same thing and write that interim order passed in favor of In favor of whom?
Nazira Begum. Nazira Khatun.
Nazira Khatun.
In favor of applicant number one.
One, my lord.
Is applicant number one is extended till the next date of listing. Same order will go. This will be.
My 24.
দুজন মানুহে সিহঁতে কনফ্লিক্ট কৰিছে
Hmm?
দুজন মানুহটো ক্লিয়াৰে কৰিছে
Wait, wait, no, sir. Look, in this case, well, as on today, 27 days, allegation of theft. In this case, I have taken well, 3 plays. First of all, arrest memo, my lord, not.
Item 40.
40.
My lord, here charge sheet submitted, my lord.
Arrest memo, my lord, not.
Charge sheet submitted.
Yes, my
They
lord.
didn't appear before the
Consider,
court below, my lord.
You go there and appear.
My lord.
And
Mr. AK Azhar, 11 council.
your lordship have judgment, my lord, in this regard, not signature.
Not charge sheet.
Heard
I'll
Mr.
consider, your lordship.
Charge sheet has been filed, so you go there and post
that
that.
proper.
You can place that also there.
My lord, that
Heard
photo.
Mr. AK Azhar, the Learning Council, representing the accused applicant, also have Mr. D. Sharma, Learned AP for the state. Is an application section 283 of BNS 283, claim for granting bail to the accused applicant in connection with Narivan PS case number 110/2026, registered under sections 305 bracket small e stroke 3 bracket 5 of BNS 2023. The learning APP submits that charge sheet in the instant case has been already submitted. By charge sheet.
By charge sheet number 98 of 26, dated 31/7/26.
In view of the abuse of the Learned Council, the clinical accused applicant submits that liberty should be granted to him to approach by jurisdiction for full stop. Instant bail application is disposed of with the liberty to the accused applicant to approach the jurisdiction for appropriate relief if so advised. Accordingly.
Diploma.
In the above terms. Disposal is.
My senior is doing like,
Hmm?
may kindly pass on the message for the.
Item 50, my lord, here also charge sheet submitted.
Charge sheet submitted, who
My
is
lord.
senior?
G. Bora.
Huh?
G. Bora. So this, she's engaged in another court, so she may kindly pass this.
Pass it over for time being.
My-
Tell her the charge sheet has been.
Already
submitted.
informed. He knows about it.
41.
Lordship, item number 41 and
42 same, my lord. Here charge sheet submitted, my lord.
You go and appear. then.
15 days time may be given, madam.
Heard, Mr. Your name?
DLM.
G. Ali Dalal Council, appearing for the accused applicant, also heard Mr. D. Sharma, Dalal APP for the state. This is an application under section 452 of BNSS. Doing for 3 years bill to the accused applicant. Accused applicant in connection with Lordship PS case number 36/2026 under section 303 bracket 2. Stroke 61 bracket 2, stroke 317 bracket 2, stroke 318 bracket 4 of BNS 2023. The Learned Council appearing for the the Learned APP submits the charge sheet in the instant case has already been filed by charge sheet number.
At charge sheet number 183 of 26, dated 28/7.
In view
26.
in view of the episode, the Learned Council appearing for the accused applicant submits that submits that. Is there any interim order?
Yes, madam, that may be extended.
Where is the interim order? Which date? Submits that, in view of the opposite, the Learned Council submits that liberty should be given to him.
24.
To approach the appropriate court. Huh? Which date?
Interim granted on 24/2,
24/2.
my lord.
This court by the according bench of this court by order 24/2/2026 has granted infant years bail to the accused applicant. Full stop. In view of the aforesaid, an instant AD application is disposed of with the direction to the accused applicant. Accused applicant to appear. To appear before the jurisdiction of trial court within a period of 15 days from today. Till his appearance before the trial court. The interim order dated, interim previous bail order dated 24/2026 stands extended. Petition disposal, petition disposal. Same order, other.
My lord,
Charge sheet number.
my lord, charge sheet number same, my lord. 183 of 26, dated 28/7.
Same.
Same, my lord, same FIR, my lord, same case, ma'am.
Same order.
I'm obliged.
Thank you, sir.
मतलब hearing we are challenging order
Hmm?
by the London Trial Court whereby the demand of a vehicle has been rejected. The allegation of the crux of the allegation is very briefly is that when they during the Naka checking,
23, right?
during the Naka checking, police have found there is 105 numbers of cylinders were there which are wrapped up by some cement bags and that was inserted in the vehicle. There is no any information. Police on basis of the GD entry, the FIR has been registered. The will find on the impugn order at page 24. My prayer for Jima has been rejected only on a ground that the observation is given that the confiscation proceeding was initiated thereby. Apart from that, there is nothing. So, we the so far
Page 20.
on page 24. On that's some third paragraph.
What is the status now?
Lordship, we have not received any status report, Lordship.
We get the status report, then what happened to this? I don't think this will be available here.
Not available.
Yes, we are not receiving any notice, that it as part of mandatory requirement under this essential commodity, there is a provision to serve the so-called notice.
For provision for confiscation.
Confiscation is there, but the mandatory requirement is that notice has to be served and that the owner has to be given an opportunity that to substantiate that that his vehicle is involved.
Correct. So status of confiscation will require. So heard Mr. Your name? BK Das. BK Das, the learned counsel appearing for the petitioner. Also heard Mr. P.S. Lathar, the learned EPP for the state.
Petition.
State, Mr. State in the impugn order dated. Which is the impugn order dated? Impugn order dated 3/7/2023. Mentioned about confiscation proceedings. Confiscation proceedings initiated against the vehicle in question. Full stop. It is the full stop. CD and the LCR, the TCR has been received. However, the status of such confiscation is not available on record. Therefore, the learned, you will get it. Learned APP is directed to directed to procure a status report regarding the confiscation proceeding initiated and submit the same before this court by the next date. Next date, let the matter be fixed on.
August, Lordship, sorry, Lordship, September, Lordship, on 7th or 10th.
10th of September.
আমাকে দিবা রে নিশা কি বলবো দিস কিতনা স্যার इसमें
May I please your option? But what happened, my lord? These two petitioners were the witness in the court matter. So while giving the depositing, they have deviated from the earlier statement. The court has taken it very seriously. You have put the false evidence. So asked the bench assistant, lodge an FIR to the police station. And accordingly, FIR was lodged and case was charge sheeted immediately. And my lord, Honorable Court has taken this cognizance and the same day issued non-voidable warrant and PNA. Same day. So
So, my lord, it has not yet been served. We are willing to appear. We are before your lordship to give us an opportunity to appear and suspend the PNA and the warrant of arrest for at least 15 days, my lord. By that time, we will appear.
Case, performance in this
No, we'll see the record. It is not called for.
because record not call for lordship. Record may be called for because lordship on the same day normally.
My lord, I take the lordship, the
Never.
honorable court has taken the cognizance and immediately, kindly peruse the page 15, my lord. Page 15. Issue non-bail warrant and PNA to the charge sheeted absconding accused person. There are a series of judgments of the apex court and our own high court. My lord, PNA and non-bail warrant at the first instance is not appreciated.
Because if they are willing to appear,
They are willing to appear. We will face the trial.
appear right. Order to report.
27/1/25. Latest total.
Bottom
PNA is not returned.
25 order lordship.
Latest order is
Order.
made on 10/13/5/25. We have not been served with any PNA alert, but we have changed our residence. That landlord had told us that the police has come to serve you a notice. Then on inquiry, we found that non-bail warrant and PNA has been issued. That's why we have filed it, my lord, to last year. Initially, there was a delay. Delay was condoned by the Honorable High Court. And my lord, the case was on mention. We have brought it, my lord. Our bona fide is that we want to appear and face the trial. Kindly give us an opportunity, my lord.
Let him appear.
Instead of keeping pending.
Hmm?
Instead of keeping pending,
Within
since
10
25,
days we will appear.
since 25 it is pending.
Yes.
Right, Mr. S.C.B. Sloss, the learned counsel appearing for the petitions. Also heard Mr. P.S. Loper, the APP for the state. Instant application is being filed.
Okay,
It's include it 238/432.
That one I'm
Yes, praying for setting aside and pressing.
that one by this one.
Conviction or conviction?
No, we are not convicted, my lord.
Then why you have written conviction? In the cost,
Convicted.
cost title?
Procedural decision.
I'm sorry, but it is a
Copy paste.
Setting aside and
quashing
crossing
the
of
order, my
conviction.
lord, actually.
Hmm?
438, quashing the order, not conviction. You are not sentenced, not yet convicted. Trial has not yet started, my lord.
Then how can when this be the these kind of mistakes?
Well,
then,
it is a
then,
typographical mistake here.
typographical mistakes, no. I mean, setting aside and crossing and conviction of sentence of the petitioner.
But
How can I allow this?
My lord, kindly peruse my prayer, my lord, kindly.
Please.
When setting aside, then watch the record, perusal of the records. That is the priorest bail we moved, my lord. That was not considered. Priorest bail, that we have mentioned. That is the charge.
No. You are saying about some setting aside, quashing and all these things.
Yes.
And prayer also is not very clear. What exactly you are looking for? Set at liberty the petitioner's offences under section.
But
How
that
can
is,
they set you at liberty? Please change this. We can't be, we cannot pass any order on this kind of prayers and this kind of.
sir, I'll modify, I'll file an IA matter, modify the.
Modify it. How
Prayer.
can the court can pass an order on this? Post title is wrong, prayer is wrong.
Both I modify.
Otherwise, you withdraw this and file a fresh. That will be better.
Fresh. Yeah, no, should make it.
You will give you liberty. You file it. It will be a short petition. No, it will not take much.
Yes, kindly give me the liberty, man.
Liberty, I'll give you. I heard Mr. S.C. Viswas, the learned counsel, appearing for the accused, appearing for the petitioner, also heard P.S. Loco, learned AP for the state. While taking up the matter, certain typographical mistakes as well as misstatement and some wrong statements have been discovered by the learned counsel appearing for the petitioner. In view of the aforesaid, he prays that he should be given, he should be allowed to withdraw the instant application and file a fresh restore, taking into account his submissions and the contents of the petition. The instant revision petition is dismissed on withdrawal with the liberty to file a fresh.
Let me take your lordship. Lordship, this is, I'm appearing as a legal aid counsel here. This is filed by the informant, lordship, against the bail that has been granted to the accused person, lordship. So it's a POCSO case by the order dated 21/1/2026.
You are appealing for the informant.
Yes, lordship. Against, they had the accused person was granted bail. For cancellation of bail, they have filed this revision.
So will issue notice on this.
Lordship. Or lordship, in alternatively, lordship, because it's a POCSO case, I have also not paid for stay, it will give more trauma to the victim, lordship. Lordship may dispose it of with directing to within a time frame, because it is fixed for evidence at this stage. Victim's evidence is complete and the informant evidence is also complete.
You are coming for bail, cancellation of bail.
Lordship.
Right.
Instead, I have filed this for cancellation of bail, but instead of that, lordship, I'm alternatively, if lordship directs to, because cancellation of bail after getting it, it's a bit difficult, lordship. That is that within a time frame, if the whole case is disposed of, it's a POCSO matter. Next date is on 9/10 and only 4-5.
But other side has to be heard. Huh? Without hearing them, how can any order can be passed? Because one person has already been granted bail.
Yes,
Right.
the one accused, the sole accused.
So without hearing him,
The bail will be remain there, lordship, only that it can be disposed of within a time frame. The whole finally heard by the session judge.
let us issue notice
Lord.
now, then we'll next
Lord.
date we'll see whether that can be done. Heard MS B. Sharma, the learned legal aid counsel
Legal aid
appearing for the petition. Full stop. I also heard Mr. P.S. Loco, the learned APB for the state. The instant application has been filed by the informant. Where is the order of cancellation?
Page 16.
Page 16. Then this instant application has been filed by the petitioner under section 4, section 528. Read with sections 458 and 442 of the NSS for quashing the order dated 21/1/2026 passed by the learned additional session judge from special judge POCSO degree, allowing the bail petition number 1331 dated 3/10/2025. 25 full stop. Let notice be issued. This notice will go through you or in a usual course?
If it's POCSO.
It's accused.
Sure, yeah, no, probably not, lordship, because we are
Not going.
serving notice on.
Yes, it will not go through. Let notice be issued to, notice be issued to the respondents by way of speed post, as well as normal course, full stop, steps to be taken within how many, 3 days? Steps for notice to be taken within 3 days. Full stop, notice to respondent number 1 is dispensed with since Mr. P.S. Lakkad and AP puts in his appearance. Let the matter be listed. On 9 September,
Probably after 1 month, it will be better. In that case,
then 18 September, 18 September.
of like.
Whether in this case, scan copies of the trial court record was called. That is not received also.
That's it. TCR is the parties are duly represented. TCR is yet to be received. Let the matter be listed on 9 September.
Interim order may be called.
Interim orders of past trials. I'll continue till the next date of listing.
I am appearing on behalf of respondent number, sole respondent, my lord, for the wife, my lord.
Okay, Mr. So and so, record his name. Record all the names. His name also. Your name?
I Rafiq. I Rafiq. I Rafiq.
Number 2.
I?
Rafiq.
Or respondent number 2, Lordship.
Number 2, my lord.
I Rafiq is for is present for the petitioner, and Mr. P.S. Locker APC for
1.
And your name?
A.S. Laskar, my lord.
So for respondent number 2.
Yes, my lord. My lord, so far as my lord, interim order, my lord, that was till my lord 27, 26.
So we are extending it
My-
till the interim order shall continue till the next day.
This call for
Scan
my lord,
copy means,
scan copy of the all case diary, my lord, everything.
I mean, scan
Yeah,
copy, but hard
record.
copies.
No, my lord, scan copies now.
How will I go through the scan copies of 200?
I have the scan copies with me.
There are
I have
2000
prepared it. I'll
pages.
hand it over to
Let the matter be called.
your lordship. Call for it, my lord.
Let the matter be called.
Yeah.
We have some.
Your
other-
lordship, I beg to state, I beg to item number 49.
49.
Your lordship.
What happened?
49.
What happened?
My senior is out of town.
So you should have mentioned in the morning. Why you are mentioning now?
Actually, I was in the other court.
So
I got
should have
late.
done somebody else. 49, we right on the prayer of the learned council.
Your lordship,
You are appealing for whom?
Digos,
Huh?
Digos.
Mr. So and so, the learned council appearing on behalf of. You are appearing for the petitioner.
appeal, Lordship. Lordship, my only prayer is that the matter may kindly be fixed on 27 day of August.
Wait. The ghost the learned council prays for adjournment of the matter, citing the reason that his senior MSD Ghost is out of station. The prayer is not objected by the learned council appearing for the appellant. Let the matter be listed on
27.
27th of 27th.
Item 50.
Fifteen. 50.
Charge sheet submitted here.
So you go and appear there.
Lordship.
Heard Ms. G. Bora, the learned council appearing for the accused applicants. Also heard Mr. P.S. Locker, the learned APP for the state. And this is an application under section 483 of BNSS 2023, paying for bail to the accused applicants in connection with Nagaon PS case number 372/2026 under sections 331 in bracket 4/305 BNS. Full stop. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number
496/26 dated 19/7/26.
In view of the proceed, the learned counsel appearing for the accused applicant submits that liberty should be given to her, given to the accused applicants to approach the appropriate jurisdictional court. Full stop. In view of the proceed, the instant accordingly, the instant bail application is disposed of with a direction to the accused of, with the liberty to the accused applicants to approach approach the jurisdictional trial court for appropriate relief if advised, if so advised.
Item 46, hearing.
Yes.
There are four, my lordship.
Huh?
It's,
Who is appearing
main-
on the other side?
We had a formal party, 124 proceeding lordship.
Who is for the respondent notice served?
Sorry.
Huh?
It has been already served. On the two grounds, I have stated my lordship, there are four. The main child, my lordship, is in my custody. And there was
The other side is not there. Heard Mr. So-and-so and counsel appearing for the petitioner. Also heard Mr. P.S. Lawford, the IPP for the state. None appeared for respondent number 2 when the matter was called for. For the interest of justice, let the matter be listed after 2 weeks.
Lordship, I am appearing on behalf of Mr. S. Biswas for respondent number 2. I want to submit two things. First of all, this petition is not maintainable as they ought to have preferred.
Okay, we'll hear it some other time. Okay, record her this thing. MS so-and-so is present for the respondent number 2. Let the matter be listed after 2 weeks. After 2 weeks, no?
47.
Right, your losses, this is an application under section 480 for quashing the judgment passed by the learned session judge. The impugn order is at page 30, lordship. I'll just read out, I beg your permission to read the,
Who is appearing for the other side?
it's actually when amicus curiae and Hassan was appointed last permission.
Have we intimated her?
Already,
Have you
she
seen
received
her?
the copy also, we have informed her.
What's her name?
And Hassan.
And
Huh?
Hassan. We'll fix it up some other time, you know, the amicus is not there. Heard MS so-and-so or any counsel appearing for the petitioner. Also that Mr. P.S. Lawford and an APV for the state. However, none appeared for and none appeared for the respondent number 2. Her name is shown in the,
Yeah, the
Huh?
lordship, it is shown in the, no?
which item was this?
47.
47. It is seen that MS N. Hassan has been appointed as amicus curiae for respondent number 2. However, she is not present today. Let the matter be listed after 2 weeks.
Also,
Weeks.
date may fix.
Then it will go to 3 weeks. Sometime in tenth of September.
Okay.
Are you person? Nice. Yeah,
One and two.
Mr. I mean, without notice, it will be difficult to hear. We'll have to issue a notice.
Which one, man?
We'll have to call for the case.
Already it's there in the record.
Where is the case record?
It's in
Where is the case record?
case record, my lord, has been called for.
We'll
by
have to call for the case record. We'll go only by the case record of the court. Mr. Bhuyan.
That's what I'm saying.
Where is that?
That is with the sessions. Already 5-8, my lord, will kindly see item number 44, office note.
We'll
It
have
has
to,
been there.
we'll have to issue a notice in this case.
1 and 2.
We'll have to come prepared and.
Real one notice has been already issued, my lord.
Yes, no notice has been issued. Where notice has been issued?
Informant has
show
already
me.
appeared.
You show me where notice has been issued.
My lord, we have been heard.
Where, in which matter?
First order, my lord, the bail
Which matter?
application. my
Bail
lord.
application.
Bail application
Where?
number 682 of 2026.
Correct. So where is the record?
With regard to, my lord,
This bail application will have to call for the case diary, right?
Yes.
Case diary and TCR. I mean,
Yes.
now the TCR.
Yes.
The TCR has to come. We'll have to
Yes.
go through a procedure.
Yes.
So,
My lord will kindly see item number 44 note.
44 notes is what? 44 is a
Same item matter, my lord, same matters, my lord.
44 is a different matter altogether.
No, my lord, same matter.
That's a criminal revision.
Quashing petition.
Quashing petition, yes.
Yes,
Then-
same case,
What's
same
that?
FIR, same facts.
Okay, maybe, but we'll have to issue a notice in this.
My lord, in that case, my lord, I would pray
Okay, for let me see the 45 at
44, my lord, kindly see 58, 58. 58 is flagged. It's lying, my lord, in the safe custody of the session, my lord. We have gone and verified from the lower court also.
Revision.
Same records, same
44.
facts. Yes, office note will kindly see flagged, it's flagged also, my lord. It's received, my lord. Safe custody is there, it's court custody, my lord. 5/8, dated 5/8.
One USB device containing case record.
Yes,
So how will I go through this USB device?
my lord. It is to be put in there,
How,
my lord.
is it possible?
My lord, if it is not possible, for the convenience.
And one more thing,
Yes,
respondent number 2, I mean, whether notice has been served on him.
my lord, here, my lord, the informant, my lord, is not required, 302 case.
No. Here, you have made a party.
Yes, we have made
You
a,
have made a party and like you have not taken the steps as yet.
there is no direction from
You
the
have-
honorable court for this, my
You
lord.
have made a party and you have not taken steps.
Not required,
The
my
order has been, the order shows that service report on respondent number 2 awaited. Then office record says no steps has been taken for service of notice upon respondent number 2.
My lord,
Then-
kindly see the order, first order.
The first order says
There is-
what? Issue notice to respondent number 2, returnable on 21/7.
Yes.
You have not taken steps.
My lord,
You have not taken steps as yet. Mr. Bhuya, you want to argue the matter, but you have not taken the steps. You ask your junior why steps hasn't been taken in spite of the direction of the court.
as because, my lord, the lower court record is there.
Whatever, Mr. Bhuya, you have made a party and notice has been issued to the party in front of you when you appeared in the matter, then steps were supposed to be taken, direction was given to steps to be taken, steps hasn't been taken, it is written in the office note, you check the office note. It says that no steps of service has been taken as yet. Then, I mean, you have made a party. We have. I mean, nobody has asked you to made him a party. You have made a party. Notice.
Position of the court, my lord, who wants to delete that particular name, my lord.
No. You.
Unnecessary
I mean, there is a judicial. I mean, judicial
Actually, the 482 informant is a necessary part.
necessary party, and like that's why I mean, notice was issued. I mean, it was done in front of you. You were there, and your junior hasn't taken the steps. You ask your juniors why steps hasn't been taken. Is it?
My lord, if I am correct, my lord,
Yes.
my part was heard. Then, my lord will kindly see the order. And thereafter, it is for the submission of the learned PP, it was been fixed.
I'll just read out 2 orders. This is first order. I'll just read out the
Yes,
first
yes.
order. Heard learned senior counsel so and so. Then also heard special counsel.
PM Chandra.
Then special counsel Mr. Jayat Kamal.
Yeah.
Then says issue notice upon respondent number 2, returnable on 21/7/2026. Then meanwhile the trial court records call for and leaves the matter. Then the other order says that service report on respondent number 2 is awaited. Scan copies of the trial court record has not been received. Issue reminder. That's all.
My lord.
That's all.
No, my lord, so far with regard to this bail application is concerned, as because, my lord,
Till 1 by
the lower court record has been received. So it can be disposed of.
Bail matter. There is no notice issued as yet.
My lord, if
I have
it
to
is
receive
that,
notice,
my
I'll give
my
my
lord, what I am,
response. I'll
Notice
give my
means-
response then, my lord.
Sorry.
If the notice is issued to me, then I will make my response, my lord.
Correct.
And after perusing the case record, my lord, then I'll refer the pages where to look into, my lord.
So like, I mean, whether.
Yes, my lord.
I mean,
Because now diary loses its relevancy because there is a case record, my lord.
correct.
So learned trial court record may be called for, my lord. And it has to be in this particular case, my lord.
In the bail.
Yes, my lord. That is the procedure, my lord, we are following.
But I'm on, my lord. It's been
It's
a
a
practice.
motion stage one day.
I may be wrong, my lord, but this has been a practice in a bail application 439 or a 438. If it's been moved for the first time and the case diary has been available, suppose for a co-accused persons also is been pending and the case diary is there. So in that view of the matter, my lord, notice is not required. This honorable court can dispose it off. The case diary has been there.
The case diary has to come.
It is there with him.
It has to come from the court.
My lord,
It has to come from the
it
concerned
has
court.
come from the court in the same
It has-
custody of
it
the
has to-
session. My lord,
It has
this.
to come from the court. And like, and how this, I mean, you said how many pages? 2,000 pages or what?
More than that. 12,000 pages.
How it can be, scanned copies can be perused here and pass an order effectively.
My lord, for that purpose.
So that's why hard copies will be required.
And in the hard copy, if your lordships call for the hard copies, the trial will stop.
No, hard copies of the scanned copies of the hard copy. We are not calling for the whole original copies. But the copies has to be there. Otherwise, how will the court is going to peruse those pages?
But
Do you think this court is going to, sit down here, like, going through all the pages on the TV?
and I am there to assist this court. Everything I have printed out, whatever copy, I will assist the court. Whatever they refer to, that will be before the court. Can compare
Court
with it.
will go through only the records which is coming from the court. Coming from the trial court. Now, we will not rely on your documents.
These are trial court
We will
documents
not-
given to us.
Then you file an affidavit and place before this court.
And then 12,000 copy I have to furnish.
If we file a one-page affidavit and along with that you submit all the documents.
Okay, my lord, then let it be, notice be issued. It will be fixed in the next week itself. I'll get it. Tomorrow I am filing it by affidavit.
You file it. You file it by.
And in all the matters, my lord, I need to notice.
Next week
I'll
will
be
be
easier.
easier.
Mr. Kamar,
My lord.
trial court records are available.
No, my lord. Not called for.
In the other
We
matter.
don't have access also. Trial court will themselves send it, my lord. We can at the best assist it, my lord.
Yes.
The case diary is there, my lord.
Case
The
that is
case-
also not
that
called for. Now we
case
will not
diary
get it.
will suffice now because trial is.
Case diary will suffice, my lord.
Okay, the trial has already started. What are the statements there, evidence there that has to be produced?
My lord, 88 witnesses, my lord. I'll produce it, my lord. Copy itself by way of affidavit.
Let us see, this is not the procedure we follow, Mr. Bhuya. We follow a procedure here wherein we call for the case diary or TCR when the case is pending for trial court.
My lord, it is a case so complicated, my lord, to
It's
let
not-
the diary, according to us, my lord, according to him, it's very simple case. But there are 6 accused persons. So we have to segregate and see what is the material against them. So where we'll get all this? In the diary or in the lower court case record, my lord, which we have submitted in originals, my lord. So without looking into it, how can your lordship decide and determine this case at a fix, my lord? Without that, it is not possible, my lord. So in all fairness, my lord, let the notice be issued, give us a date and the records be called for. Then we'll take a hearing. Because ultimately, on the motion stage,
He is also right that this person is there behind the.
well,
clock,
definitely,
so-
my
so
lord.
we-
No doubt of it, my lord.
this thing.
That's why a short
So
date
he
may be
has-
given, say when except the last week, next week, my lord.
My lord, can you see the cause list item number 1, Sandeepan Garg, informant has already appeared in bail application.
There is no record. here.
No, that is victim,
This
not
is
informant.
victim.
Victim.
Okay.
Gorima's counsel.
So, my lord, it will be a never ending process, my lord. I am sorry to
No,
say.
see, Mr. Bhuya, the court process, it takes time. We'll have to follow certain procedures. And like, we cannot give a go by to certain procedure which is there and which
Laid
is
down
required for adjudication of the case.
Absolutely
and-
right.
correct.
I appreciate whatever is been falling from this lordship, my lord. But one thing is clear, my lord, with regard to the law, my lord. When I move a petition, at least one step, let us go further. At least my argument is to be there. My lord has heard it, my lord. Next week it is fill every record. I will make it
No, we
before
see,
this court.
I suggest one thing, we'll fix it up after 2 weeks.
My lord, it will be too late.
2 weeks, I will fix it up. We'll call for the, trial scan copies of the trial court record. And the next date we'll hear it. There is
And
no.
then, my lord, if the trial court record is needed, another 5 days, my lord, another 2 weeks will go.
But without that, how the court is going to hear this matter and adjudicate
Come
the
to the
matter?
conclusion.
Mr. Bhuya, there is a fast track court going on, right?
Yes.
Trial going on.
Yes.
Now, what is happening in the case, because it is not the stage of framing charge or before framing charge. It is a stage when the trial is going on.
My lord.
So when the trial is going on,
Yes.
usually
Yes.
court is not supposed to interfere with the trial, first of all. First thing. Second thing is that, okay, there are certain cases court is required to interfere. Then we'll interfere, but for that, like the court has to peruse the record. What is happening there? What is the statement? We'll have to peruse it. Without that, how the court is going to decide?
In that case, my respectful submission is this, my lord, and very limited. That, my lord, I have been charge sheeted under 304. For charge sheeting me under 304, there has to be a culpable homicide. There cannot be culpable homicide amounting to murder or not amounting to murder without a culpable homicide. And my lord, in the quashing petition I moved before this honorable court, court was about to pass a stay order. Been convinced from the materials on record I produced that whether prima facie case 304 is made out or not. That I want to satisfy before this honorable court.
Then before, see, Mr. Bhuya, you have made a party has been asked to give a notice. You have not taken the steps.
Absolutely, my lord.
You
Absolutely.
take responsibility at least.
Absolutely. I agree, my lord. I take every word by word, my lord. But what I am on is this. If I can prima facie give me the opportunity, because no notice has been issued, it is as good as in motion stage. Give me the opportunity to satisfy your honorable court. If it is not satisfied, issue notice, no issues. If my lord, my part is over and I can satisfy from the records that it is a case where no charges can be framed, then my lord will stay against the whole proceeding. Why I will face the trial?
Absolutely, we'll, but for that, like court has to first see whether trial court records are required or not required.
Not required, my lords. My material charge sheet and
Because
161 statements and everything.
So that stage is already over.
That is not over because it has come back to that stage again.
See, already TCR has been called for, correct? In the other case, and only the notice has to be served. Notice hasn't been served in the other case. As far as the bail petition is concerned, the court is not convinced that, like, without perusing the case diary or trial court record, the court will adjudicate the matter. This is not a stage. This is not a case wherein, like, the court will go with only with the submissions.
It's not submissions, my lord. It is based on record of the prosecution, my lord.
So we want to
I will
see
be the last person to make a submissions, my lord.
That's what we want.
On the basis of prosecution documents, I am saying there is no case.
So, Mr. Bhuya, we are not saying that we are not going to hear you. We are just saying that, like, let the process be followed.
How long?
How long is the? We'll see the next.
June and August, my lord. Now.
Let's see the next date. Let's see the next date.
And there has to be a judicial order to that extent, my lord. The scan hard copy has to be there.
The hard copy has to be there.
Because there is a judicial order, scan copy is there.
No,
there is scan copy.
Scan copy. I mean, this court is not going to look into those.
That's what it is,
there
has to be some consistency.
If there would have been like 30 pages, 40 pages,
Yes,
it is fine. That is fine. Then I can go through it. There's no problem. But so many pages with all this evidence, how this court is going to do it? You understand?
When we will refer, which way you're looking?
It will be done.
My lord, the scan copy has been called for by one court. Now there will be another order now where hard copy will be called for, my lord.
No, hard copy will be called for in the bail application.
Same thing,
whatever is called for. We are not going to disturb that.
Yes.
In the bail application, the hard copies has to come.
Hard copy of what, my lord?
Hard copy of the TCR. Trial court record. Scan copies.
Trial court record.
Yes.
My lord will appreciate the case diary also.
Yes, appreciate the case diary.
So hard copy of the case diary also.
Yes.
I will get it.
We'll get it by next date.
That is for the prosecution.
My lord. Yes, they have to get it, my lord. It is
Definitely.
under that will not
If
do.
court pass an order, my lord, we'll definitely
Yes,
produce
let
the
it be
case.
done.
We always carry it, but we have to give, because nowadays.
The hard copy also, I mean, like the case diary also, you can get scan copies, there is no problem.
No,
with
no, I
that.
will get the original. Why I say, my lord, nowadays actually, earlier when the charge sheet is submitted along with the charge sheet, the case diary was annexed and closed.
Mm.
Nowadays, under BNS is not so.
Not required.
No, no, not required, and it is a direction that it will be in the custody of the IO.
Okay.
Earlier, once the charge sheet is filed, IO's duty is in. Nowadays, it's a different process, my lord, under the BNSS. And this is a case under BNSS, my
So
lord.
you give me a comfortable date, I mean, after 2 weeks.
So whenever direction is required, I'll ask my IOs to produce the case diary. I'll produce it before your honor. In the earlier bail rejection order by
So,
honor.
Mr. Commander, let me ask you one thing, whether it's possible to go through this pen drive and like.
I don't think so, my lord, because if I refer to page 80,
Mm.
then your lordship, he will refer to page 20, so there will be
And
some.
and now, what will be the volume of case there?
There are 8 volumes, my lord, 8 volumes,
TCR.
8 volumes. 8 volumes,
it will
my
be
lord.
how many
8,
pages?
8, no? Eight.
How many
12,000
pages?
pages, man.
Huh?
12,000 pages.
We have with us.
10,000 pages.
I have made 30,000 pages so that I can assist this court. And these are prosecution
So
documents.
that's what the
submitted to
court
me.
is saying, kindly file it in your affidavit, court will look into them. Court has expressed that way, but trial court record is required of the authenticity and many other things, my lord. There's the
I get the
procedure.
certified copies of the
You
evidence
get all the certified copy and file it.
for the client minor.
See, Mr. Bhaiya, it will be better. We call for the.
I leave it to the wisdom, my lord. I have no position to dictate.
No,
It's
no,
a request, my lord.
I'm not saying like, I mean, I'm not saying that what you are saying is totally.
I'm lucky that my lord has heard me to that extent and is kindly accommodating it. But when I see, my lord, in my all this experience in my criminal courts, my lord, that an innocent person without any material, iota of material, has been frame charged, and thereafter going through the trial, nothing coming on record. It is contrary. The witness is proving it that he is innocent. Then thereafter he is after 300 plus, my lord, he is behind the bar. Poor family, my lord, only earning member.
Will it be possible for them to like get it, all these things, hard copies within such period?
Why not, my lord, if there is court order? If they cannot, my lord, I'll file an
No,
affidavit.
how
my lord.
much time it will take? That's what I'm saying.
I'll not furnish a copy to them, my lord, because case diary will be there.
No, not
Okay.
required.
I'll file with an affidavit with all assurance giving in, whatever copy they have given in, it's in my bag only. I was asked my junior to carry it, my lord, 2 bags.
No, we'll do one thing. I mean, we'll call for the hard copies.
Hard copies, my lord.
Hard
Let it be
copies.
done. And the case diary, my lord. Without fail, my lord.
And the case diary.
Without fail.
And we give us a date when.
27th, my lord.
27th.
26, my lord. Lower court is closed. my lord.
26, right?
Can it be done on, September, some first week?
May I pray, my lord, 26, my lord.
26
With
week?
folded hands, my
Yeah,
lord.
I understand.
Understand, my lord, he has been under suspension, no salary, nothing, my lord.
Uh,
He has gone to depression, my lord.
Then let it be on Thursday, 3rd September.
May I pray, but
For
Thursday.
me, no issue, man. Because it will take some time to make copies, man.
So again, we'll have to give another date. Let it be on Thursday, September 3rd.
yes, and the liberty be given
That's
to
a
me, my
hearing,
lord.
it's a hearing date.
Huh.
So we'll take up.
Yes, my lord. Yes, I am 100% satisfied, my lord. To the court, I'll satisfy this honorable court. I vouch for it. And my lord, give me the liberty to file an affidavit with regard to all prosecution documents. I'll file it. But I will not supply copy to them. But because it's been like, I cannot afford to.
No, that's fine. I mean, like, we'll call for it.
Yes,
Call
ma'am.
for it. We'll call for it.
Your lordship will kindly pass the order, man.
Yes. Item number 1, 2.
One today.
But Mr. Senior Counsel, assisted by so and so for the accused applicant. Also heard Mr. J. Kamal, learned special public prosecutor. Learned special public prosecutor assisted by Mr. PP Doctor.
Yes.
P Doctor.
Either.
P Doctor, the learned counsel for the state. For the state. Then you write, this is an application. Under section 483 of BMSS 2023, paying for granted bail to the accused applicant in connection with sessions case number 256 2025 under section 105 of BMS 2023. Then you write registry to call for the photocopies of the TCO. TCO.
Including the evidence, man.
Including the evidence.
Yes.
Including the evidence. Including the evidence recorded till date from the court of the is from the court of the exclusive fast track.
Yes, ma'am.
First track, exclusive
Fast track
first track.
court, fast track sessions court, Kamrup Metro. Let the matter be listed on 3rd September. 3rd September 2026. Same order will go in the other matter also.
Item number 2, ma'am.
Item number
One
2
and
also
two
same order.
Different accused, minor.
And other matter, then if you take steps.
Yes, in the item number 44, minor, for one, I will take steps.
44 you take
Immediately,
steps.
ma'am. I'll do the
44 you write.
by tomorrow, minor.
44 you write. Mr. A.K. Bhuya is present. Learned Senior Counsel assisted by so-and-so is present. Present for the petitioner. Mr. Jad Kamar, the Learned Special Public Prosecutor is assisted by Mr. P. Doctor is present for respondent number 1. Office note dated 5/8/2026 reveals that steps for service of notice upon respondent number 2 is yet to be taken. Full stop. The Learned Senior Counsel submits that he should be allowed some time to take steps for service of notice on respondent number 2. 2 days time. 2 days time is allowed to serve notice upon the respondent number 2 by way of speed post as well as usual course. Let the matter be listed when.
And the LCR and all repetition, minor. Then it will be covering both the cases, ma'am. No confusion there.
Then you write photocopies of the LCR. Registry to call for the photocopies of the trial court record, including the evidence recorded till date from the court of the first track court, that you read.
In the case diary, minor.
And the case diary.
And the case.
And the case, the other matter also, and bail also
case
case diary, along with the case diary.
Case diary may be directed to us, madam.
Yes, I.
The case diary will be produced by the parent. You write, case diary will be produced by the learned
Special
public prosecutor. This matter when is to be fixed?
I think on the same.
Together, minor.
Because together it may be
Minor,
difficult.
the argument for the bail application and the quashing tool will be the same, minor.
Because this, because this first, it will.
This is, it may be a little bit different.
Because, why I say,
Other date.
because on the third.
We'll fix it in some other date quashing.
Minor.
Quashing will be a little bit different arguments.
No, that's definitely. But first there must be service of notice, what he has got to say, he will say. Then for admission, it will be listed for admission hearing, madam.
Yes,
After completion of service.
So we'll list it on.
Any date, madam.
3rd of September.
Okay, then we'll list it on 3rd. Then we'll see on.
Yes.
Yes.
The
That's
other
why I
person
said
appears.
it will be on the 3rd. It will come up in order column, this one.
Yes.
And the prayer of interim would be considered on that day.
That we'll see. I mean, let the other part.
My lord has made a query with regard to that particular judgment, my lord. 2022-10 SEC, my lord, I have gone through many a time. Satyendra Kumar until last page 137, my lord, will kindly see.
Page 1.
137, last page, my lord, will kindly see. 100.11. Bail application ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise, with the exception being intervening application. Am I clear, my lord? That's why I submitted it. It's 15 days, my lord. It should be 14 days.
The BA before the trial court or before the high court?
All courts.
All courts.
Application for anticipatory bails are for 6 weeks.
6. And my lord has made a query with regard to his conduct. I will receive it.
That will.
On that day.
You want this? I mean, I have seen this,
Yes.
but I was thinking 6 weeks or both.
I have read it, I don't remember.
No,
There
I
is
was
a-
thinking that bail 6 weeks. Because of anticipatory bail, they have made a difference.
There is difference between the two, a person behind the bar and I'm obliged, man. I'm sorry, my lord, if I have otherwise.
Oh.
And I was feeling, I have a feeling that this
Nothing,
matter at
you
last
are-
got listed
you
here
are- you
and
are-
I'll get justice.
You are
But
fighting for
for my
yourself,
client,
fighting for your client.
Client, yes.
You have a cause.
Yeah,
And we'll also have to hear the matter as per the
absolutely,
procedure.
absolutely, as per law, man. I don't need anything, my lord. I am on the law.
Fine, we'll hear it. I mean,
Yes, obliged.
Well, there are two more items.
Two more
30
items.
Yes. 30 is probably.
Who is appearing?
Mr. Bora.
Miller's item 30 made
30 is on
two
BC,
notes.
my lord.
My lord, by these applications, my lord.
Miller's item 30, I am appearing
More.
30 for the petitioner.
33 to tomorrow. 32 hours.
Scan copies of trial record has come.
No, my lord, I don't think so.
Scan copies hasn't come as yet.
Miller's, in my matter, 4 weeks ago, this order was passed. Miller's, so Miller's,
But
I'm not.
your matter is a heavy matter, so the documents are also heavy and bulky. So it is taking some time to reach the court.
Yes, in fact, I wanted to inform my lords that my bail application was heard on the soft copies itself by this honorable court. My lords,
So this is for what? This is bail. This is criminal review.
no charge. This is a
So
revision.
we'll wait for some time. We'll wait because on the other cases also we have called for the
Scan copy.
scan copies. So we'll
Milos,
have to wait for some.
if hard copies are
We are seeking for the hard copies because we cannot go through the scan
Without
copies.
the copy, it will be difficult.
very well, my lords,
Yeah.
I have one more request because by the last order, my lord had granted time to the learned PP to file objections. He has not filed any objections.
Objection, Mr. Kamal, objection.
We prepared it, my lord. We'll be filing it, my lord, because in the meantime we have to look into that.
about 1 month they are preparing.
No, that's true, my lord, because we have prepared in 5 cases already filed.
The same.
Last thing.
No, but because there can, my lords, when it is being heard on the trial court records.
No, without
why
objection
each
also it
time-
can be heard
why
if we
each
don't file
time
it.
there has to be an
Executive
objection.
First of all, my learned friend has to be assured that whether he will file or not. Since 1
Yes.
month.
He's
is
saying
going on,
he's filing.
you just, if you want to file, you file it. Or otherwise, my lord, every time, 1 month. since
What
he-
every time? This is the second time.
Ma'am,
But-
always also, that what he says that.
No,
he is going to file
Mr.
or not.
Bora is there. This is the second time he has asked for. This is not.
Sorry.
No, see, no, this is
So, my lord,
the first time when the notice
got
was
it.
issued. Notice was issued. He
Yes.
was asked.
Oh, yes.
He said that he'll be filing.
My lords,
Yes.
So do it,
then
But
my lords
I-
record that
Okay,
if
In between, I'll file it, my lord. That's
Anyway,
fine.
anyways,
no
we'll
objection.
list it when
Any date, my lord. September.
September, sometime in the sometime in 10 September or 17 September. You tell us.
my lords,
September 17 will be better, Thursday, my lord.
may I, my lords, may I say something? My lords, my lords, since this is a fast track court, day-to-day trial, my lords, I am challenging the charge. My lords, by the time, my lords, it will come up for hearing. My lords, the way they are going with the trial every day, my lords, they
So
will
it will be
not
over. It will be over. So you wait for that. It will be better.
my lords, rather,
Why don't you wait for that?
Oh.
Yeah, it's a
rather
fast
I
track
would
court.
say,
See, yourself, you are saying that this is going on day-to-day basis, and that's a material fact to be considered while adjudicating this case also. Correct. So you are admitting that like the fast track court is going on a reasonably good speed. So you wait for the conclusion, let it come to a logical conclusion. Why you press for this petition?
My lord, I'll pray that his submission may kindly be recorded.
Sometimes justice hasn't is also justice, not
No, that is what I'm
given.
saying. You see, like, I mean, if
Bringing
a
the
fast
good
track
track.
court
not good.
concludes I mean, then it's better for you, something will come out.
My lords, if it concludes, then my entire petition will become infructuous.
But you will get the result of the trial. That is what you're looking for, isn't it?
No, my lords, may I say something? That
Yes.
hasn't result, my lords, because my learned opposing counsel, Mr. PP, is not filing any objection.
No, we are asking them when they are going to file it.
My lord, 17 your lordship has suggested, I'm
Okay, we'll fix it on 17th, and by that time they will file the objection.
Yes,
As well as
I'll file.
Which
I
they
hope
do not
I
file.
hope we will receive the trial court records also.
In the meantime, madam.
Yes.
And last opportunity to file
Heard
objection.
Mr. A. Mishra, the learned counsel, appearing for the petitioner through video conferencing. Full stop. Also heard Mr. Jet Kamar, the learned. This is CID or what?
Yes, my
Jet
Yes.
Kamar, the learned special public prosecutor, CID, assisted by Mr. P. Datta, the learned counsel for the respondent state. Trial court record is yet to be received. Mr. Mishra has submitted that that objection from the state is yet to be filed. Full stop. Taking into account, taking into account the submissions made, let the matter be listed on 17th September 2026. In the meantime, the learned special public prosecutor shall file his objection in the case.
In
Okay.
case the objection is not filed, even then it will be.
Yeah,
heard,
yeah.
my lord,
Sure,
without
sure.
objections.
Be rest assured, I'm
And
filing.
other one,
Other one is
stay
33.
order will go.
Yes, my lord,
Obliged.
but
Is it the same?
number two.
My lord, here, my
Hmm.
case is a different than of what my learned friend just now.
I won't be able to take up this matter.
My lord,
I will let this matter be listed before an appropriate bench. This matter I won't be able to take up.
what?
In fact, I don't know. Other matters also. He's connected to other matters.
It's correct.
But I think
Connected to the other, whereas I am not in the scene, my lord. I have been languishing in jail, my lord, about more than 9-10 months, my lord.
no,
And
this,
if you're not-
this person is known to me.
Ah,
I mean, we were classmates once upon a time.
All right, right. Well, that's to you. Because of first now the problem so far I am having, my lord, that this court is not taking this matters, other courts also not taking the matters. So this is going on like this, my lord.
No, the problem
That is
that all these people are known to each other. I mean,
Known to each other, they're known to each other. That somebody want, some of the honorable judges also not want to take up these matters also, because of the
that
fact.
I cannot comment upon, but like this court is not saying
But
that.
that is the problem what I face, my lord, as on now face, and because of whose, my lord, I have been languishing in jail since about nothing, my lord. If your lordship kindly see, even out of track, my lord, if your lordship kindly see that it's not a case of homicides, my lord. How and that is what it
So
is.
a
No.
factual thing will be decided in a
That's a
trial
different
court or
thing.
by
No,
the high
before
court.
that, before trial court also, if your lordship kindly see the statement, my lord. It's not a case where the conspiracy come. If I have to make a conspiracy, the High Commissioner of Singapore has to be there also.
Definitely, we'll bring it. Don't worry. When the situation will
The
come,
Tonmoy Fukonn has to be there, my lord. They
We'll
have
bring
to be a
him.
listed witness, my lord.
when time will come,
Then definitely, I'm
then
not saying
I
that.
was saying before time.
No, what we are before time.
Okay,
I know the
Mr.
anxiety what I am
Bora,
feeling, my lord.
Mr. Bora,
Because I am languaging.
All
We
equies are like you.
No, not is a matter of when you have been languishing in jail, you have spent about 9 months.
So many
available
accused,
time without
so
doing
many
anything.
accused. What
It's
is so
very
special with you?
It's very easy to say standing in front of
Anyway,
a court.
this matter I won't be able to take up.
My lord.
Us.
I'm passing.
Well, list it before the
List it
appropriate.
to appropriate bench. I won't be able to take up this matter because of the obvious reasons.
My lord.
So other matters will take it up.
Yeah.
Obliged. Obliged.
Much obliged, man.
Ah,
Man, fucking.
Same kind of.
Yeah.